Mr. Chairman, it's 2 o'clock and you have a quorum. Everyone except for the vice chair is here.
Okay, well, we'll go ahead and get started then. Good afternoon. The Memphis and Shelby County Board of Adjustment is hereby called to order for its regularly scheduled meeting of October 28, 2020. My name is Tim Rainey. I'm chairman of the board. Mr. Josh Whitehead serves as secretary of the board. Mr. Whitehead, may I get a roll call?
Ms. Baker.
Here.
Mr. Claybrook. We have Carson unmuted. Okay. 481. He's up. No. Let me unmute. There you go. Mr. Claybrook.
I'm here, Josh.
Thank you. Ms. Doss.
Present.
Mr. Jackson.
Here.
Mr. Malazri.
Here.
Ms. Scarlock.
Here.
And Mr. Chairman.
Here.
You have a quorum.
Thank you. The Memphis and Shelby County Board of Adjustment is the oldest appointed governmental body in Memphis and Shelby County. We were established in 1925. The board hears appeals from the administration of the zoning ordinance, requests for variances from the zoning ordinance, and requests articulated by local zoning laws adopted pursuant to the enabling legislation. The 8 members of the board are appointed, 4 by the mayor of Memphis and 4 by the mayor of Shelby County, with confirmation by the Memphis City Council or Shelby County Board of Commissioners. We serve without remuneration. At this time, I would like to swear in the staff. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do. Thank you. May I get a motion from one of the board members to approve the minutes from last month's meeting?
John Jackson, so moved.
All right, being moved. Is there a second?
Second.
All right, I hear the second. Is there any discussion?
I'm here.
Okay. Okay, hearing no discussion, all those in favor of approving the minutes signify by saying aye. Aye.
Aye. Aye.
Any opposed? The motion passes. Mr. Secretary, please provide us a secretary's report if there is one this month, and then explain the procedure for today's meeting.
Yes, sir, Mr. Chairman. Before I read from my secretary's procedures, I do want to remind everyone, maybe who have not yet joined us for one of these telephonic meetings, that we will use both our staff reports. We'll reference them on at least a few cases, particularly when we talk about some of the conditions of approval, as well as the PowerPoints. Both may be found on our YouTube page, which is youtube.com/C as in channel /Division of Planning and Development. You can also locate that from our website, which is a very long and confusing website. But if you Google Memphis and Shelby County Board of Adjustment, you'll find our agenda. The agenda hyperlinks the YouTube PowerPoint, as well as the individual staff reports, those conditions that I mentioned. So, as far as our procedures, let me to the right page. We will proceed as follows. I will introduce each case as listed on the agenda. Copies of the agenda, as I mentioned, are on our website and on the YouTube page. At the conclusion, so for each case, staff will give a presentation. At the conclusion of that presentation, we will first hear testimony from the applicant, followed by supporters of the application, followed by opposition. Under our rules of procedure, each side is allowed 10 minutes total to provide testimony, and that's cumulative. The chairman may allow additional time, provided he allows the equal amount of additional time to both sides. And those times do not include Q&A between board members and anybody who's speaking. I would recommend that the board members, since we're on this telephonic call, if they have any questions of the speakers, they get those questions in before we move on to the next person. but you also have the opportunity before we close the public hearing to ask a question of any speaker, opposition, supporters, or the applicant. At the conclusion of that testimony, we will close the public hearing by a motion and then deliberate, and the body must have 5 affirmative votes to approve any cases, regardless of the number of board members present. All motions made by the board will be made in the affirmative, and the body also can, in addition to approve or reject a case, it can hold a case for up to 3 months for consideration. All section numbers that we refer to come from the Memphis and Shelby County Unified Development Code, which was adopted by the City Council and the County Commission in 2010. I will introduce the entire code and make it part of today's record, thus dispensing with the reading of individual sections. This body is vested with the power to act on these cases before it under the provisions of Chapter 9.22 of the Code. Mr. Chairman, I submit that all cases have been filed in proper order, all applicants have been notified of this hearing, and all other notice requirements have been fulfilled.
Thank you, Mr. Secretary. At this point, the board will establish a consent agenda. To establish the consent agenda, the Secretary will call out each eligible case. If any member of the audience or staff or board member objects to the case being placed on consent, he should do so by saying so. We should have a list already of who, as far as the audience, who's going to be on the phone with us and know that. But if the board or staff wishes to hear a case, please let us know. Once the consent agenda is established, the board will vote on all cases placed on consent as a whole and will not hold individual public hearings on those cases. Mr. Secretary, which items on our agenda are eligible to be placed on consent today?
The Chairman, as perhaps the applicant and the body knows, number 1 has been withdrawn, and we did get that withdrawal before the agendas went out, so we did notate that on the agenda. Number 3 is a consent as a approval. That is, agenda item number 3 is docket BOA 2069, located at 2655 Broad Avenue. The applicant is Luis Toro, and the use district is the CMU1 Commercial Mixed Use District, with the request being a variance from paragraph 497A2 to allow continued use of a non-conforming sign. Agenda item number 4, which is docket BOA 2092, that's located at 2933 and 2935 Tishomingo. The applicant is Bubba Shepherd. The use district is the R6 Single Family District, and the request is a use variance from 252 of the code to permit, a train is going by, Mr. Chairman, to permit an addition to a legal non-conforming duplex. Agenda item number 5 is docket BOA 2093. That's at 285 Waring. The applicant is T. Douglas and Ashley L. Gilland. The use district is the R10 residential district, and the request is a variance from subsection 329, pursuant to subsection 329F to allow an encroachment into a 300-foot recorded front yard setback. That brings us to agenda item number 7. That's docket BOA 2095, located at the southeast corner of Cooper and Tillman. The use district is a single-family district overlaid with a planned development assigning a CMU2 district to the property, and the request is a variance from 497A2 to allow a welcome sign at that shopping center, or in front of the shopping center. Bringing us to item 10, that's docket BOA 2098, that's at 800 South Carterville, Arlington. The applicants, Ricky and Florence Busey. The use district is the CA Conservation Agricultural District, and the request is a variance from paragraph 272A3 to allow a pool to be located in front of the home. Item number 12, agenda item number 12 is docket number BOA 2100. The location is 185 South Goodlet. The applicants are Edwin and Ray Crenshaw, and the use district is the R10 Residential Single Family District. The request is a variance from paragraph 272A3 to allow, interestingly enough, an existing pool within the front yard, as well as a garage encroachment into that front yard. And finally, a little bit of a surprise, late-breaking news. Mr. Chairman, agenda item number 13, we just received a request from the applicant to hold that in abeyance for 31 month to allow perhaps a redesign of the proposal. Agenda item number 13 is docket BOA 2001, located at 210 Hawthorne. Applicant is MGR Memphis 3 LLC. The use district is the RU multifamily district within an overlay. As a historic overlay, and the request is a variance from item 452C1B to allow parking within the front yard.
Okay.
And that is it.
Very good. I'd like to see if someone from the board would then make a motion to approve agenda items number 3, 4, 5, 7, 10, and 12 as conditioned by staff, and to hold agenda item number 13.
Vice Chair Madeline, so moved.
All right, being moved. Is there a second?
Second.
All right, being moved and seconded. I'd like to remind the board that by voting on the consent agenda, he or she affirms that he or she has read the staff report and is in full agreement with the conditions. Mr. Secretary, may I get a roll call, please?
Mr. Claybrook.
Yes.
Ms. Scurlock.
Yes.
Vice Chair Savage Towns.
Yes, I find that the standards of 9.22.6 of the UDC are being met and will not be unduly detrimental to the properties in the vicinity.
Madam Vice Chair, you're very echoey. Just noting that maybe if there's something you could change. I don't know. Mr. Malazri.
Yes.
Mr. Jackson.
Yes.
Yes.
Ms. Doss.
Yes.
Ms. Baker.
Yes.
And Mr. Chairman.
Yes.
That's 8 ayes.
All right, thank you very much. Those cases, case number 3, 4, 5, 7, 10, and 12 have been approved, and 13 as a hold. Mr. Secretary, will you call the first case on our regular agenda today?
Yes, Mr. Chairman. That brings us to agenda item number 2, which docket BOA 2068, located at 528 East Parkway North. The applicant is NCE Realty, LLC. The use district is the RU3 multifamily district, and the request is a variance from item 452C2C to allow the continued use of parking within a front yard.
Okay, I assume the applicant's there. Can Mr. Smith give us a brief staff report on this?
Hi, yes, members of the board. Seth Thomas with the Office of Planning Development. So this property is located at 528 East Parkway, and is a variance to allow a front yard fence for an apartment complex located within an RU3 zoning district. Go to the next slide. And I guess we can probably just skip this, as it's right at the intersection of East Parkway and Summer Avenue. As you can see here from the aerial, the yellow outline shows the property on the north side of Forest Avenue, which is the location of one of the curb cuts that needs this variance. If you go to the next slide, we can see on the zoning atlas that the zoning is residential mixed use 3, or residential mixed use 3, with north being RU1 into CMU, east being RU3, to the south R15, and then to the west it's basically Overton Park. Next slide. From land use map, we can see the land use is sort of a mix of multifamily, single family, and commercial, with, of course, institutional to the west. Next slide, please. And then here's the site plan. So the parking in question is not located, or was not supplied on the site plan that we received from the applicant. However, the sort of gray box to the southwest is sort of the rough location of where the front yard parking is currently existing, and you can see also the curb cut within the site plan that shows where these cars are entering into the front yard. The next 3 slides are just site photos showing the front yard parking that's gated here with the curb cut from Forest Avenue. And then I guess relevant to this is engineering comments that we received from engineering that say that require sidewalk repair for ADA compliance along East Parkway, but then also the curb cuts on Forest were approved in 2017. However, the gates that were installed both in this front yard parking, which is the need for the variance, and the rear parking, which is legal, have gates that are not conforming with gate regulations within the UDC. And engineering requests them be removed. Next slide, please. So in conclusion, the applicant is seeking relief from sub-item 452C to little c to allow front yard parking for an apartment building. This application is retroactive as they were cited by the Office of Construction Code Enforcement for establishing front yard parking without going through the variance process initially. The engineering comments additionally show that both the front and backyard parking gates are non-conforming, and we believe that granting this variance will cause a substantial detriment to the public good and will impair the code. And so staff is recommending rejection. However, if approved, staff is recommending the following conditions: that any change or deviation from the site plan shall be submitted to the Board of Adjustment. We're suggesting that the developer must comply with the engineering comments, and then furthermore, the developer must establish plantings to constitute a Class 2 Type C buffer around that front yard parking area if it were to be approved. And that concludes my presentation.
Thank you, Seth. Are there any questions of staff right now?
I have a question, Mary Baker.
Yes, Ms. Baker.
Mr. Thomas, can you go to the site plan that shows the area of the parking? Back to that slide.
Yeah, let me.
Okay. Here's my question. It almost looks like there's a driveway to East Parkway, but there is not, right?
That is true. Yeah. Okay. So the initial site plan, and one of the reasons it was held was that I think they were having trouble trying to find the original site plan, as I believe the architect that did it is no longer working with the company when he did it. But yeah, there was initially a curb cut that was supposed to be off of East Parkway. However, that curb cut was never built. And so although it sort of is shown there, it is not present. And it's really only the 2 curb cuts on Forest Avenue that give entry into that lot.
Okay. Second question, the setback, the gate setback would have to be 20 feet. Is that correct for this number of units on a
yes, ma'am.
minor street? Is that right?
Mm-hmm.
So they could do that with the back one. I don't know how much would be involved, but that one in the front, of course, they could not.
Yes, the rear gate would be able to be moved. I believe if it were to be put even with the building, that would actually make it 20 feet. So it would almost line up with the actual building itself.
Yeah, so they couldn't possibly do it. Okay, those are my questions. Thank you for answering them.
Yep.
Any other questions for Mr. Thomas or other staff? All right. Hearing none, is the applicant unmuted yet?
Yes, sir, Mr. Chairman. If you can hear me, my name is Jeffrey Smith. I'm an employee of NC Realty, and I'm the applicant.
Okay, if you give me your address as well, then I'll swear you in.
Okay. Yes, sir. My name is Jeffrey Smith. My address is 1500 Hopewell Road, Memphis, Tennessee, 38117.
Okay, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay. All right, go ahead. You have 10 minutes if you need them all to kind of discuss this with us. So you're on.
Yes, sir. Thank you, Mr. Chairman. I would like to cede my time here at the beginning to Mr. Kirk Caraway. This renovation was done on this property under the supervision of Judge Potter in the environmental court, and Mr. Caraway was our legal counsel through that process. And he's here not as counsel in this particular presentation, but as a witness to the process regarding code inspection and approvals during the renovation process. So if I may, I would like to cede time to Mr. Caraway to explain that to the board.
Very good. Mr. Caraway.
Yes, Mr. Chairman, can you hear me?
I can. Since you're acting almost more of a witness as opposed to
Correct.
representation, do you mind giving your address and
Sure.
letting us swear you in?
Sure. Address here at my office is 80 Monroe Avenue, Suite 650, Memphis 38103.
Very good. And do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead, sir.
Mr. Chairman and remaining board members, just to kind of give you a little bit of a background, I represented the gentleman who owned this piece of property prior to NCE Realty purchasing it. And that property, prior to the rehab, was subject to oversight by the environmental court because it had been cited for numerous code violations. So at the time I got involved, the property had not yet changed hands to NCE, but was in very much disrepair. NCE came in, purchased the property. All of that had to be court approved, which it was. And then NCE likewise had to present to the court a rehabilitation plan concerning what they intended to do to get the property consistent with code. That was done. I looked through my file. I will tell you, and I don't know if you're familiar with this or not, but the environmental court is not very heavy on paper practice. Most of what we do is there in the courtroom, and code enforcement is there providing updated reports at every court appearance. The city is represented by the prosecutors, and Judge Potter was on the bench at this time, I believe. According to the documents that I looked through in my file, it looks like I became involved as early as April of 2016, and there were multiple court dates between April and 2016 until August of 2018. During that period of time, NCE Realty presented a plan. The plan was approved. They then proceeded with rehabilitation efforts. Those took a little longer than anticipated because of some issues with MLG&W getting electricity and transformers and all the like hooked up. That eventually got resolved, and in August of 2018, Judge Potter signed off on an order of voluntary dismissal. In that order of dismissal, he found that the condition of the party was rehabbed, and they dismissed the case against NCE Realty because it was indeed rehabbed, and they approved everything that was done. Code enforcement was involved throughout the entirety of that litigation and had to sign off before the court would agree to dismiss the case. If you have any questions, I'm happy to entertain them.
So, Mr. Caraway, as part of that was looking at site plans, looking at the progress made on the property, all that was kind of going before the court as that was happening in real time?
In real time, yes. That's the most important thing. During the actual rehabilitation of the property, in the different phases, and as I said, there were multiple court dates, so the inspectors would come out, and their protocol is to show up and inspect the property within a week prior to each court date. So if we went to court every month or 6 weeks or potentially maybe 8 weeks, then the inspectors would go out in real time, approximately a week or less prior to each court date, come back to court and report to the judge about the progress.
Okay, and the parking and the gates were all installed during that time, correct?
That's my understanding, yes. Now, I didn't actually go to the property, but of course we relied upon the inspectors to do that.
Right. Okay.
Yeah.
Are there any other questions for Mr. Caraway?
I have a question, Mary Banks. do you know whether the permit issued for this included a site plan that showed those gates?
That I do not. That was respectfully above my pay grade. I was hired and retained to, number one, get the transfer of the property approved, which it was, and secondly, navigate NCE through the oversight process through the environmental court, which we did. But driving down into the specifics, that would be more of a project manager question.
Okay, thank you.
Mr. Chairman?
Yes, sir.
Josh Whitehead, I have a question for Mr. Caraway. Maybe the same question that Ms. Baker asked, just styled a little differently. Mr. Caraway, so the court, it sounds like from you, not necessarily perhaps see a site plan, but was the court, did the code inspectors or your client or you share with the court any kind of photographs or other indication that either the parking, well, specific to the parking or the gate, the two items are potential zoning variances? Was the court aware of those two locations, of those two items?
Good question. The inspectors would take photographs when they would go, and historically what they did was they loaded them onto a laptop, and then there was a large projector screen in the courtroom, and they could click through those pictures to allow everyone in the courtroom to see them. To answer your question directly, do I recall whether the actual gate and the parking lot was photographed? My memory is not that good.
Okay, thank you.
But I will tell you that the inspectors were inspecting the entirety of the project and the entirety of the property. I do know that. So, I mean, we're talking electrical, plumbing, everything.
Okay.
Mr. Chairman, one more question for Mr. Caraway. Were the gate and the parking installed prior to the court finaling this product?
I don't know about the gate. I do have a recollection of the parking lot being discussed because there was an issue with an MLG and W pole being moved with respect to a curb cut, and that was one of the holdups that we had on getting everything approved, was having that particular post moved. So with respect to the parking lot, I do have a recollection that that was taking place during that. With respect to the fencing, I don't know the answer to that question.
Okay.
For the gate. Oh, well, I can say this, and in fact, this is reflected in a couple of the orders. Let me see here. I'm thumbing through it real quickly because I want to use the same language that the court did. We had orders of continuance that the court would issue each time. And I did see, okay, on the order of continuance dated, this one, it resets the case to April 13th of 2017. And in the notes in the order, it says keep secure and maintain status update on completion in mid-May. By stating keep secure and maintained, they did require my client to make sure that that building and specifically the entire construction project was secure, because they did have problems with people in the neighborhood trying to get onto the property to steal things. And so one of the big issues that the environmental court always
would do it with the gates. They recommended that we move a utility pole, which we had to do. We've got that opening, that curb cut is 35 feet wide. It's only for 5 cars. But everything that was done with approvals from everybody. We had, code enforcement was there almost every week. And as well as I went to a lot of the meetings, downtown to Judge Potter's court. In fact, I had lunch with Judge Potter at the very beginning, and he instructed, to get this done, do a good job. And if there was any issues, with things just like this, for me to report that to him, and then he would, take care of making it happen. So, as far as what we thought we did everything, with approvals from everyone, meaning, the code enforcement.
Right. Gotcha. Okay. Are there any questions for Mr. Wolf? Hearing none, I guess I would just go, Mr. Smith, if you'll talk to us just for a minute. I got one, well, we might have other questions, but what are your thoughts on the conditions that were given from the staff if this was approved? And so that would be, the main things would be complying with the engineering comments, which is moving the gates. Clearly, you can't move the front gate. You could maybe move the back gate. And the other would be putting plantings in the front, some sort of buffer over that parking area. I want to get your thoughts on those conditions.
Yes, sir, Mr. Chairman. I'm sorry. I'm trying to go to them in the document itself so that I can be looking at them as I reference them.
Sure, absolutely.
And I'm in a PDF and I have lost my place, and I do apologize.
Yeah, I'm gonna find them and tell you what page they're on. They are on page 15 of that PDF.
Page 15. Thank you.
And about right in the middle. Yeah.
Okay. Let's see. Okay. Thank you very much.
The first one is just about deviations of the site plan. It's really 2 and 3 would be the ones that we're talking about.
Okay. So yes, sir, Mr. Chairman. Thank you. For number 2, as you mentioned, when I speak of the 2 gates, I'll refer to them as, I guess, east and west. They're both on Forest. The
Gotcha.
east gate is the one that leads into the back parking lot. So that's
Yes,
what
sir.
I'm referring to when I say east. That is the one that I guess theoretically is possible to do in that if it were flush with a building. It would require us to possibly change, that's more our concern, but change the gate. Our current gate is a sliding gate, and that would, of course, have to be a swinging gate at that point. If it's a condition for approval, then we're not hard. We're not hard against that. Seeing that it could be done again, that's not really possible for the west gate to
Right.
to have that type just because of the layout of the property. So I'm assuming then that condition 3 is what is addressing the west gate or parking.
Yes.
Well, let me take that one at a time. The parking for the buffer around the front parking. I'm going to be honest, Mr. Chairman, I looked up what that meant, the Class 2 Type C, a while back and did not recently, so I do not have fresh in my memory what that is. And I'm assuming that's some sort of landscaping buffer.
Yes,
and
sir.
I'm sorry to ask questions of you.
Oh, no, not a problem at all.
Then we would not be, we wouldn't have any real opposition to that, creating, excuse me, some sort of landscaping buffer around the parking there. We would not be opposed. And as far as the gate there, I don't know if I know what, in this case, for that specific gate, what complying with the engineering comments would even mean physically, on the ground there.
Yeah, it sure doesn't. I don't think it's possible with the current parking. You can't get 20 feet without basically losing almost your whole parking lot, away from the
Right.
fence. I don't know if that's even possible.
Right. I don't
okay.
know if this is important. Oh, I'm sorry, Mr. Chairman.
No, you go ahead. Go ahead,
Again,
sir.
we're not opposed to those. We would welcome both the office, the planning office, and the board's input there. As far as this may not be important as the gates go. Again, we have sliding gates, and they are the tenants are issued remotes, basically like garage door openers, so that they're not having to drive up and push anything in. They're able to open those as they approach. I'm not sure if that's an important bit of information, but it wasn't said, so I wanted to say that. But I'm sorry to ramble on. Thank you, Mr. Chairman.
No, you're fine. I have a couple questions
Mr.
for
Chairman?
staff. Yes.
This is Archie Wolf again. I just wanted to say that the reason that the gates are sliding gates is because of the number of parking spaces that were required by code. There was 22 parking spaces required, and we looked at doing swinging gates, but if you did that, then you ruin the parking spaces. So the sliding gates gave us the amount of parking that was required, and that's why they were there.
Gotcha. Okay. Makes sense. I do have a question for someone on staff real quick. I know that the 20-foot or whatever the setback is for a typical gate is, that's in the code. Could somebody explain the public policy behind that exactly to me? Like why we want that as opposed to it just being flush with the fence?
I'll take that, Mr. Chairman. This is Josh Whitehead again. The code has varying depths of gate regulations, and it depends on the size and the traffic volumes on the adjacent street. The whole idea is, and this maybe goes to Mr. Wolf's point, that if you're queued up at a box typing in your code, you are not doing that with half of your car sticking out into the road.
Gotcha.
So it's basically 20 feet provides for a full car length generally, because where you sit from the driver's seat, most cars would get it out of the right of way at 20 feet.
Okay. And this is for anybody on this, is there any box, like let's say I wanted to go visit my friend that lives there, how would I get the gate to open, or was it really I can never park on site if I'm not a resident? How would that work?
Mr. Chairman, I can answer that.
Please do, sir.
Parking on the street is something that's legal on that side street. There is a gate where a pedestrian can walk up and either enter a code and, go through a gate. But as far as someone parking inside the space, they do not park in there. And by having the remotes, they don't really wait to get in. They just use the remote. The gate opens up. They pull through. So all of this was, primarily maximizing the space so we could have the amount of parking that was required, as well as for the safety of the people who lived, in the unit, so that they didn't have an accident. There was a curb cut on Parkway, but driving out that curb cut would be an accident. So this was just the best solution that we could get to. And I met with the fire department 2 or 3 times to come over and talk about all these things and the traffic flows and what would happen if case they have to come over there. And so we went through all these issues and, presented this stuff to Judge Potter's court, before any of this stuff happened. And we really thought that we solved all those problems at the time. So
Sure.
Thank you for letting me speak.
Absolutely. Thank you, Mr. Wolf. And I got one more question for staff, and other people might have questions too. As far as this Class C buffer, the Class 2 Type C buffer, explain to me what that looks like versus they have landscaping on the west side of that front yard. What would need to change there? There didn't look like to be a lot of room on the south side, just based on how the parking's situated, but what would need to change in that landscaping?
I can speak on that. This is Seth Thomas again. So basically the Class 2 Type C, the reason that was sort of requested is that still allows for a non-site proof fence, and then it's adding shrubs and it's adding evergreen trees. The intent being the evergreen trees would be added along the parkway side of it to sort of block that thing while making the fence be able to stay non-site proof, as the fence is currently, wrought iron, you can see through it. If we were to move it to a Class 3, it would have to be a site proof brick fence. And so the Class C or the Type C Class 2 would just really make it so they could plant some evergreens to add as a natural barrier while keeping the fence as is.
Okay, okay, very good. Thank you, Mr. Thomas. Are there any other questions of the applicant or staff? Hearing none, I assume you guys are ready to at least discuss amongst ourselves. So is there anyone that would move to approve? Oh, Mr. Jackson?
Yes, sir.
Did you say something?
I have a question for staff. Yes, sir, I have a question for staff. Okay. Mr. White, I think you might be able to answer this for me. Is it my understanding that the Tennessee Department of Transportation requested or has a problem with the curb cut on Parkway? Is that correct?
That could, I don't know for certain, but I know it is a state highway, and they obviously have some control over, I don't know if they have a permitting process for all state highways, particularly ones like this that are in the middle of a city, but they do have final say over curb cuts on state highways, so that's potentially correct.
I guess I can also sort of speak on that. The site plan that was submitted to engineering showed that curb cut, and our engineering department said that that curb cut, if still existing, is not legal and has to be taken away. I'm assuming they came to that conclusion through the Tennessee Department of Transportation, although I don't have confirmation of that. But that curb, the site plan, as Ms. Baker spoke about earlier, that's shown on the site plan we received, the engineering said that curb cut, if still existing, has to be removed because I believe it is too close to the intersection just north in order to be legally there.
Okay. All right. Mr. Chairman, I have another question also.
Go for it.
And for staff. The regulations that govern the parking in the front of this building have been in the UDC for how long? Just what, 5 years?
I believe that was part of the original UDC, which was 2010.
So, okay. So, all right, you've answered all my questions. I'll save the rest of it for discussion between board members. Thank you.
Okay, any other questions before we move to discussion? All right, hearing none, could somebody give us a motion to approve BOA 20-68 as conditioned by staff?
So moved, John Jackson.
Okay, is there a
Vice
second?
Chair, second.
All right, okay, do y'all have thoughts on this? Thoughts on the conditions? Thoughts on it in total?
Mr. Chair,
Mr.
John
Jackson
Jackson.
does. Go for it, Mr. Jackson.
I'm trying to understand why we're having all this discussion about why the parking is in the front yard. I mean, it's pretty clear from what the UDC said, and it's been there for quite a while, that there can be none. So, and I don't know if I'm right or wrong on this. I think I'm right. It doesn't matter what I don't think the court ruling is relative to that. The bottom line is the UDC governs that, period. And the process to get around that is to come to the Board of Adjustments and ask for a variance. It wasn't done. So no matter how we got to where we are, we're here. And it shouldn't be there. So I guess the point for us is really not how we got here, but are we going to let it stand or are we not? Mr. Chair, your opinion on that, if I could kind of put you on the spot?
I'll let you put me on the spot. When I think about this property and what used to be there and how improved it is now for using that existing structure, getting the parking they needed under code, and they did some stuff. Yeah, I agree. They should have gotten a variance, but I kind of get when they're going through all these other processes how they may have forgotten. I don't really have a problem with it being there on this property.
Okay.
Mr. Chairman?
Yes, ma'am. Ms. Baker.
Yeah, I see this a little differently from Mr. Jackson, which is unusual. To me, I think this site is unusual. With the because it couldn't have enough property to provide parking for the number of units that are there already. And so I think it meets that part of a request for a variance. And then, I mean, I could be convinced if any board members felt this way, that, you know, the gates, I think it's good to have a gate for this apartment, given the location of it and so forth. And, you know, I don't see backing up into forest with these two units, and especially the way they have designed it. So I could be convinced to let them keep the gates where they are too. And so anyway, that's my 2 cents.
Mr. Chair, if I may.
Yes, sir.
I don't disagree with either one of y'all. I'm just saying that the debate of how we got here is irrelevant. The point is, are we gonna give them a variance so they can move on or not? And I'll be honest, I agree with what you said, Mr. Chairman, clearly that, you know, it's 1,000% improvement. Ms. Baker, I agree with you. I mean, they had to meet the letter of the law some kind of way, and if I lived there, I would feel better with my vehicle with a gate there securing it as well. So the reason I want to understand all the facts in it before we make the decision is to basically say, you know, I don't have a problem with it. I think it's a great improvement. Doesn't matter how we got there. It's whether we feel like we're going to vote and let it stay, or we're going to tell them rip it out. One or two.
Right. To me, based on your comments and Ms. Baker's comments, I think what we need to do, I think that we probably would be fine with condition 1. I don't think that I want them to change the gates as they are based on just how they're being used and how many people are parking in there. And it's just whether or not we want to have the Class 2 Type C buffer on the western edge of the property. And that would be all I would really want to discuss, although we can discuss anything else. But that's where I think that we just, once I get that figured out, I'm ready to vote.
I'm with you, Mr. Chairman.
So I'll put you on the spot, Mr. Jackson. What do you think about that? You're our landscape guy. Do you think that buffer is needed on the East Parkway side of the property to put the evergreen trees?
I think some form of concession should be there and some small evergreen trees to help kind of screen the parking, since it is a deviation from the UDC. I think some additional landscaping there would be okay, and I think that the project could move forward as is after that.
Okay. Would you be willing to accept a friendly amendment? I think you were the one that moved this to strike condition 2 and to change condition 3 where the Class 2 Type C buffer is on the East Parkway side of the parking area as opposed to around the front yard parking area?
Yes, sir. I would be amenable to that. Yes, sir.
And then Ms. Savage-Towns, would you re-second that?
I second that.
Okay. Is there any other discussion on this case? All right, I'm assuming you're ready to vote. Mr. Whitehead, will you give us a roll call vote, please?
Yes, sir. Ms. Baker.
Yes.
Mr. Claybrook.
Yes.
Ms. Doss.
Yes.
Mr. Jackson.
Yes.
Mr. Malazri.
Yes.
Vice Chair Savage-Towns.
Yes, I find that the standards of the UDC of 9.22.6 are being met and will not be unduly detrimental to the properties in the vicinity.
Ms. Skurlock.
Yes.
And the Chairman.
Yes.
That's 8 ayes.
All right, you are approved. Thank you, gentlemen, for coming down. Mr. Secretary, will you call our next case?
Yes, sir, Mr. Chairman. And I have a quick note. If you're having YouTube issues, it go out, but if you just press refresh, if it happens again, that should cure the issue. That brings us to agenda item number 6, which is docket BOA 2094. That's located at 2040 Madison. The applicant is Turner Holdings, LLC, represented by Nathan Hicks. The use district is the CMU3, Commercial Mixed Use District, and the request is a use variance from Section 252 to allow certain accessory uses to a dairy.
All right. I assume the applicant's present. If we could get a staff report, please.
Yes, sir, Mr. Chairman. Since Mr. Penzis is doing one set of duties, he can't do this set of duties too. Only I can double task. And let me get my YouTube video up. And Mr. Zena will be advancing the slides. I already gave the posture of this case. This is a request, a use variance, based upon the code. The code says you cannot have an accessory use in a district that does not allow the principal use that accessory use serves. Next slide, please. The industrial use in question, as I mentioned, is a dairy. This was originally a Forest Hill dairy. Forest Hill was purchased, which was a local Memphis company, which was purchased by Turner out of Covington, and subsequent to that was purchased by Prairie Farm, which is out of downstate Illinois, I believe. On the screen right now is the, in yellow on the right-hand side, is the specific area of the dairy site that we're talking about. This is, interestingly enough, zoned commercial, whereas the front part, the southern part that faces Madison, where the main facility is zoned industrial or EMP employment. Next slide. Mr. Penzis, in his staff report, gave a detailed history of this case. We believe that the EMP industrial zoning was done as a correction, a rezoning cleanup throughout Midtown to recognize some of the use variances that had been approved by this body. The southern portion, the southeastern portion, which currently the dairy has been a dairy since 1929. The southwestern portion, which is now the parking lot that serves that dairy, was a Swift and Company ice cream manufacturing concern. So based upon those use variances, at some point, that property was at EMP. The back, quote unquote, or the northern section, which is still zoned CMU2, I believe was zoned that way to reflect a third use variance for a third use, and that was the JCC, the Jewish Community Center, which had been located at that site, which, interestingly enough, was the last remnant of the East End Park, the East End Park being a 19th century privately owned recreational area for Memphians. The map on the right shows our land uses. We can see that this property is owned by is surrounded by a mixture of land uses. The current, or the subject site, is purple, which is identified as industrial, with commercial largely along Madison, and brown multifamily and yellow single family to the northeast, northwest, and north. Next slide. And the longer the meetings go, Mr. Chairman, the more stalled YouTube is, although I've been told if you refresh it, it doesn't do that, so I'm refreshing now. Here's the view of the northern portion, the northern street that abuts the northern portion of the site that's the subject of this use variance. In 2017, an application was submitted to our office to allow a fence of a height that is not otherwise permitted in the code. Fence height waivers are one of the types of matters that can be approved administratively by staff. That's the code calls that an administrative deviation. So these pictures on the slide right now show the results of that, of the approval of that administrative deviation. That was conditioned upon this masonry type wall along Jefferson with some additional landscaping. I believe the pre-existing landscaping was pretty minimal and probably limited to the two pine trees that you see. Next slide. And here is the southern portion of the subject area. You see the wall kind of encloses this area. Again, this was the old JCC site. That subsequent to that was a bar, backstreet bar, which was a questionable use perhaps in the CMU3 commercial district because for those of you familiar, it teetered on that fine line between bar and what the code calls adult entertainment. But that was the last non-dairy use that you see in the picture here on the left. That is the structure involved. The use variance would permit that structure to serve as an accessory to the dairy as a storage facility, and then the parking that you see would be accessory parking. What the applicant would like to do, and what has compelled us to recommend approval, is move some of the trucks, ironically, that are close to Madison in the industrial district, away from the public realm, or the Madison public realm, and towards the north part of the property behind the dairy. Next slide, Ms. Gina. And here are the main facility, pictures of the main facility. Part of the conditions of the administrative deviation for the fence was to add the landscaping that you see here along Madison and the side street Morrison, as well as install a sidewalk along Morrison. For any of those of you familiar with Molly La Casita, or what's that bar right next to it? That
Monkey.
Thank you.
Monkey.
That sidewalk did not exist prior to this administrative deviation. And then the site, the photo on the right shows various years of improvement. Somewhere in there is the 1929 structure, and obviously subsequent additions to the original structure. Next slide. The applicant has submitted a site plan with this request. As I indicated, the building we used as storage, and then the parking on either side will be used for the semi-trucks. And this is not unusual for this site, but our zoning lines may adhere to parcels that existed a long time ago, but today our zoning boundaries typically crisscross a property. Here you see that the industrially zoned area does go all the way up to Jefferson on the right or east side. That's where those semi trucks are, or trailers are parked in a northwest, northeast, southwest fashion. But the area highlighted in red is the subject of this discussion, and you see additional trucks there. Next slide. We did do an analysis of the consistency you need to call in from your, I think, can y'all hear me?
I can.
Yes.
Okay.
Yes.
Are you getting feedback?
I'm not getting any.
No.
Okay, I might.
John Jackson.
Okay, well, I'm going to call back after.
I'm getting some feedback.
Okay, Mr. Chairman. I am going to hang up and call back.
Okay.
Let me finish my presentation quick, since y'all can hear me. Some others may not be able to hear me, but we'll do this quickly. We did find this project consistent based upon the adjacent land use that I mentioned before. And final slide, Mr. Zena, who is the one that maybe can hear me, which makes it particularly difficult to go through these slides. Here's our conclusions. We do recognize the fact that this is a long-standing industrial, albeit industrial use that has been around for 91 years at this location, and has recently upgraded its facilities, so the chances of it relocating have gone from probably not very likely to even less likely, and we believe the granting of this variance would not cause substantial detriment to the public good, neighborhood, et cetera, or substantially impair the intent of the code. And next slide has our conditions, which are in your staff report, pages 21 to 22. And with that, Mr. Chairman, I'll relinquish the floor, and before I hang up and call back, I will see if any board members have any questions for me.
Does anybody have any questions for Mr. Whitehead at this point?
This is Vice Chair Savage Towns. Quick question: the back portion of the facility, does that abut a neighborhood? I can't quite see it on my screen.
There are some, I would say, probably circa 1960 apartment buildings. There's probably about 10 of them, and they're kind of like a horseshoe-shaped building, and they line the north side of Jefferson, immediately facing this site. Yes, so it is residential along the north. And Mr. Zena, if you can hear me, if you could go back to one of our maps that show a zoomed out area. To the west, Court Avenue kind of runs into the site. And if you go west, that is a largely single family street, all the way to Tucker, which has a light on Madison.
Okay, other questions of Mr. Whitehead? All right, hearing none, we'll move on to the applicant at this point. Is the applicant present with us?
I am. Can you hear me? This is Nathan Bix, First Quarter and Johnson, 130 North. Good. Hey, Mr. Chairman, two things. I'd like to reserve 3 minutes of my time for rebuttal. And secondly, we submitted some pictures to illustrate our presentation, and my YouTube is not working. I was following along, but it's no longer working, so I can't see what's going on, and I don't know exactly how to negotiate that.
Okay.
But
hold on one second. Let's see. Mr. Zena, do you have any of his pictures that can help us with that? And if Mr. Bix, if you'll try like restarting or refreshing your YouTube, I can see them.
Okay. Well, I tried that.
Yeah.
But let me make my little pitch to you, and then
let me swear you in real quick for the record, okay?
Oh, sure. I'm a lawyer, but I'm happy to do it.
Oh, well, no, if you're representing them, then you go ahead.
Oh, okay. I'm happy to be sworn in, but I'm an attorney. I work at the Burks, Porter, and Johnson 130 North Court, and I'm here on behalf of Applicant Prairie Farms. So Mr. Whitehead did a nice job of kind of encapsulating the proposal. Just to refresh, the dairy's been here for 90 years. It employs over 140 people with high-paying, mostly union jobs, and it's the central distribution point for schools and hospitals and institutions and retail outlets throughout the Memphis area. And it's composed, as Mr. Whitehead told you, of 2 zoning parcels. The front zoning parcel, which is the main plant on Madison, is zoned EMP, and it's appropriate for the uses of the dairy. And that parcel goes in kind of what I would call a pie handle shape all the way back to Jefferson. And so there are trucks that are parked in that pie handle all the way back to Jefferson. In 2016, we learned that the subject property was not appropriately zoned under the UDC for its ancillary or accessory uses for the dairy. And since that time, the building, which is the subject of the application, and the trucks that had been parked on the subject property have been moved, and the building's been emptied. And that building, which sits there today, is empty. It's abandoned. After we learned it was not appropriately zoned, we cleaned it out, and dairy took all of its stuff and moved it off-site. And it actually is the last. When I was a child, I went to day camp at the JCC there, and that's the last building that's left from the JCC plant. It's the old gymnasium, and it was used to store cartons and containers and business records. And what we're asking to do is to allow the dairy to continue to go back to using that as a storage facility, as a passive storage facility for cartons and containers and business records. But the fact that it had to be emptied out and moved, its contents moved to another site, has increased the amount of truck traffic that comes and goes from the site because they're forced to go to the off-site storage to retrieve things and bring it back. And so one of the things we would like to accomplish by putting some of the passive storage activities back into the abandoned building is to reduce the truck traffic that it has to go back and forth from the site. The second thing that we'd like to do is to move the trucks that are currently parked on the EMP parcel on Madison off of the street frontage and back next to where the pie handle is. Trucks are currently legally parked. We would, if you look at our site plan on page 15, you would see that we would put trucks next to them, sort of in the same pie handle. And this is a part of the dairy's intermediate term plans to improve its streetscape and to make improvements to the front of its building. They want to beautify the structure. They want to try to improve the Madison streetscape. And in order to do that, one of the things they would like to do is to take those unsightly trucks that are parked on Madison and move them off Madison. So what we're trying to do is essentially four things. One is to use the abandoned building for passive storage, which would, 2, reduce the amount of truck traffic to and from the site. 3, move the trucks off of Madison so that the site improvements that they want to make to the Madison frontage can go forward. We have agreed. We suggested conditions to the recommendation of the staff that are designed to accommodate this, and I think frankly are to the mutual benefit of the neighborhood and the business, because they extend the sound resistant wall in condition 3. They improve the lighting plan that's currently on site. There's one Cobra head fixture that no one's quite sure who owns. We thought the city owned, and the city says they think we own. But what we'd like to do is to submit a improved, upgraded 21st century lighting plan that would be reviewed and approved by OPD. We would limit all the traffic coming, commercial truck traffic coming and going to Morrison off of Court. We would specifically prohibit idling of engines or refrigeration units for the trucks parked on the subject property. And 3, we would agree to a condition that we would move the trucks off of the Madison frontage so that they could be moved back off of the street front and parked in a place that's not as visible from the public street. So we think that these are a proposal that benefits both the business and the neighbors. And I'll just conclude by saying we agree to all the conditions. Some of those are self-imposed and things we worked on with the staff. But if you'll allow me one personal note, it's amazing to me, and I say this respectfully to everyone, because a lot of the people who object to this are my personal friends and my colleagues and even my relatives. But none of them actually took the time to examine the proposal that we're making. They just reflexively oppose anything that the dairy comes forward with. No one asked me, and no one's inquired about what we're proposing. They don't know that we're trying to reduce the truck traffic. They don't know that we're trying to move the trucks off of Madison. They don't know that we're trying to create conditions to limit the idling of the trucks and the operation of the refrigeration units and all the other conditions that we put on there. They don't know that the dairy intends to upgrade its Madison frontage. None of that. Nobody asked me any questions about this. They just lobbed in opposition to the proposal without knowing what the substance is. So respectfully to all my friends and relatives and colleagues, this is a little bit, in my view, like cutting your nose off to spite your face, because these are things that the dairy wants to do to improve not only its operation, but also the entire neighborhood. So I'm happy to answer questions, and I'd like to have a couple minutes after my opposition speaks to have a rebuttal.
Well, you've done good. You've reserved yourself 3.5 minutes instead of your 3 minutes.
Oh, good. Thank you. I don't know about my pictures. I'm sorry, Mr. Rainey. I don't know what to do about my pictures. I can't see them. And I
The
don't
only
know
picture
if
I
it's,
see is I see a picture of the back of the truck that's looking to it looks like looking to the east down Madison.
okay, well, let me tell you what I remember the pictures to be, and I don't mean to use
Okay.
up I want to save my time, but we wanted to show a picture of what the site was before before we removed all the trucks and emptied the building. That was one. One, we wanted to show the trucks parked right up on the Madison frontage. Those pictures were taken yesterday, and to also illustrate the improvements, the landscaping and sidewalk and street repairs, and the sound resistant wall that we put into place. We wanted to show how, what those improvements are. And we wanted to show, as I said, the trucks that are parked right up there that we want to move off the street so that we can get them in the back and make the improvements to the front of the building. So I don't have it in front of me, but that's what the point of it was. Thank you.
They're slowly scrolling through right now, so we'll be able to see.
Okay. Okay. If you have questions for me.
Yeah. Is there anybody else has any questions of Mr. Bix? All right. Hearing none. And is there anybody else to speak in favor of the applicant?
No, sir.
Okay. With that, we're going to move to the opposition. So I have a list of people, I believe, on this case. If I can get it to that screen to pull up for me.
Mr. Chairman,
Yes.
we were going to go in the order in which the numbers show numerically, so that means Ms. Portia Stevens is first.
Okay, very good. Ms. Stevens, are you with us?
Yes, I am.
Okay, will you give your name and address for the record so I can swear you in?
Sure. Portia Stevens, 1233 North Parkway.
Okay, do you swear to tell the truth, the whole truth, and nothing but the true stuff you got?
Yes.
Okay, and so we have 3 people to talk, and we have 10 total minutes. So I just wanted to kind of give you that lay of land, but go ahead and tell us what you'd like to share with us.
I'm speaking on behalf of MidtownMemphis.org, and as a resident and a patron of Overton Square, most of the Midtown stakeholders that we have conferred with are opposed to Turner Holdings LLC proposed to request to expand of industrial warehouse use in their semi-trailer truck parking on the commercially zoned section site. Now, this request does not meet the 9.22.6 criteria for variance. The application responses for 9.22.6A1 and 2 are inaccurate due to the subject parcel's frontage along Jefferson Avenue and other viable uses in this growing section of Midtown. The requested expansion of industrial uses does not meet 9.22.6A4 because it does not consist with the Memphis 3.0 plan for the Overton Square as a main or as an urban Main Street community anchor. The approved 3.0 plan envisions this district to be safe, a walkable neighborhood with thriving mixed-use centers, diverse housing options, active public space, and strong connections between anchors and the adjacent neighborhood. What I'd like to say is that, we have over 40 signed petitions or 40 signatures on a petition for residents in the Tucker Jefferson neighborhood that oppose Turner Holdings LLC to expand. The noise is a major factor. I hear Mr. Bix talking about improvement. The noise factor is a huge concern. Also, there's an eyesore. It's an eyesore. The traffic is ridiculous coming off of Madison Avenue for those who want to walk to Overton Square, want to walk to visit neighbors. I mean, walking up and down Jefferson Avenue, that is not appealing at all for new people that are interested in moving into Midtown to possibly become property owners, So we support the adjacent residents in being firmly opposed to the proposed expansion of industrial use on Turner Holding LLC site. And we urge you to reject the BOA 2094 variance request. Thank you.
Okay, are there any questions for Ms. Stevens? All right, very good. Thank you for joining us, Ms. Stevens. I think we're going to move on next to Mr. Gordon Alexander. Are you with us, sir?
Yes, I am.
Okay, will you give your name and address for the record for us?
Gordon Alexander, 179 South Rembrandt Street, Memphis.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, and we have 7 minutes and 39 seconds left, just so you know, so go ahead.
I have a question for Mr. Whitehead. Mr. Whitehead?
Okay.
Are 18-wheelers in the current zoning at the back 3 acres of the lot on the north side of the property, are they 18-wheelers now allowed by code in that particular area?
Mr. Chairman, why don't we get all the questions on the floor, and then at the conclusion, I'll answer any questions that have been posed.
Okay. Okay, very good.
Well,
Mr. Gordon, will you let us know what else
I
you have to
needed
say?
that. I needed that before as a preface to my comments. I need the answer to that. Anyway, we've been through this in 2016. When they were cited for code violations, they bounced around, Turner Dairy bounced around in Judge Potter's environmental court for a couple of years with nothing being done. I work for the Midtown Action Coalition. We have had numerous dozens and dozens of complaints that have come to me and other people about the deafening noise, the glaring lights of the people who live on Court and also on Tucker and Jefferson behind the property on the north side. It seems to be just a deafening noise that keeps them awake at night. The 18-wheelers that rumble out of there are certainly a traffic concern on Madison Avenue. And I'd like to ask Mr. Bix, if I may, how moving trucks, tractor trailers and large trucks to the back of the property away from a commercial street back closer to a residential neighborhood is going to help the neighbors and stifle the noise of what's occurring right now. It just seems to me that Turner's been there for 80 years, 90 years, and they've outgrown this spot. And what they want to do is try to get a variance at the expense of the neighborhood to further their own gains. And it just seems very unfair to me. And if Mr. Bix at some point could address the fact of how do you decrease truck traffic, keep your business going like it is now, and also reduce the noise. I don't know how idling trucks at 4 o'clock in the morning, how you can stifle that noise. I'm against this in support of the neighborhood only. I live 2 blocks away on Rembrandt Street, but I'm not directly affected. But there are a lot of people that are, and they've been complaining for years. I urge you to reject this application. Thank you.
Okay, thank you, Mr. Alexander. Are there any questions for Mr. Alexander by the board? Hearing none, thank you, sir. We're going to move to Ms. Stark. Are you with us, Ms. Stark?
Hello?
Hey, Ms. Stark?
Yes.
Yeah, would you give your name and address for the record for us?
Yes, it's Lori Stark. I live at 2081 Lee Place, 38104.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead and share with us. Right now I have 5 minutes and 24 seconds left on the opposition clock, okay?
I won't be that long. I live on a dead end. Lee Place is a dead end off of Cooper, and I live at the dead end. My house backs up to Jefferson and the dairy. I've lived here for over 30 years, but for the past couple of years, the noise from the dairy has just been nonstop, like 24/7. Those refrigerated trucks that they use for storage now run 24 hours a day. Kind of sounds like a jet engine wanting to take off, but never does. The noise has really increased since they expanded a few years ago, and there are already so many trucks in the back. Why would they be allowed to move more trucks back there that affect our neighborhood? Anyway, it's really a great residential neighborhood, and Overton Square is booming. The last thing we need is more semi-trailers running 24/7 and more noise. I can't go outside in my backyard without hearing this constant low humming sound. That's what I said. It sounds like an airplane, but never takes off. I think they need to move these semi-trailers to an industrial site where they won't bother the neighbors. They did build a wall on the north side of the property, but it doesn't keep the noise from coming over the top of those walls. And that's, we can hear that on our street. They also didn't build a wall on the east or west side so that the neighbors on those sides are bothered. I've talked to a lot of our neighbors, and I'm kind of speaking for all of them. No one wants this variance to be allowed in our neighborhood. It's not an industrial site and shouldn't be used as one. So I am opposed to case 2094, and I would appreciate your denying this variance. Thanks.
All right, thank you, Ms. Stark. Are there any questions for Ms. Stark? All right, hearing none, and then there's no other opposition, correct, Josh?
Yes, sir, that is correct.
Okay, then we're going to move back to the applicant, or Mr. White, could you answer the question that they had about the trucks being allowed back there? I think Mr. Alexander asked.
Yes, sir, Mr. Chairman, and I finally found it. I remember adding this language based upon a request by Councilwoman, now Clerk Halbert, because we had some tractor trailers parking at a former commercial strip center on Getwell. But yes, we do have a provision in the code that says semi-trailers, shipping containers, and storage pods shall not be permitted as accessory structures except in the industrial zone districts. And so that is another reason why this is before you. That is section 271J.
Okay, thank you very much.
I'm sorry. Yes, sir. With all due respect to my brother Whitehead, I just would like to point out that the industrial zoning goes all the way back to Jefferson. It's what I call a pie handle. So those trucks that are parked back there that Mr. Alexander refers to are legally parked in the EMP zone. I think that's what he's referring to. So I would just say that Ms. Stevens, she doesn't live close to there, and she talked about speaking on behalf of the adjacent neighbors and talking about walking down Jefferson. Of course, there's an 11-foot fence that we put there that's supposed to be sound resistant and landscaped, that you can't see anything that's going on in the dairy property when you walk down Jefferson. Everybody makes comments about the noise, and I would point out to you that we've added two conditions that are addressed to specifically the noise. One is the extension of the sound resistant wall, condition 3, and the no idling of the engines or use of refrigeration units is condition 6. But the most important thing I want to call to your attention is the communication, the correspondence that you received from the neighbors that live directly adjacent to the facility. Is at what would be page 34 of your staff report. I did not solicit this. I did not know this was going to be before you until I got the staff report. But I want to read to you. These are the Bel Air Height condominium units, and there are two people that sent this in on behalf of the condominium owners. And I'm just going to skip, and I'll tell you, I'm not going to read the whole thing. And I recommend to you, so I'm not accused of unfairness or just picking stuff out, that you look at the whole thing. But I just want to read to you what they say, because they live directly next door to the facility. They share the property line with the, there's fanfare going on about the variance requested by Turner Dairy to be able to park semi-trailers in the back of the properties. A resident of the adjacent Bel Air Heights condominiums. I have firsthand knowledge of any noise and disturbance from the dairy. Many other citizens opposing this variance do not live anywhere near the dairy and have their own agenda against the dairy. I'm going to skip a little bit. It seems that, to the third paragraph, it seems that many in the neighborhood and many outside the area will go to great extremes to cause problems for the dairy. They have been in this location before Over Square was in existence. The dairy has done more than it has been required to do to benefit the neighborhood. The installation of a concrete back wall to block noise and views into the property from Jefferson and Bel Air Heights condominiums was not asked for, but greatly appreciated. Before they were forced to move their trailers to the back of the property during the last assault by a certain group, That's good. That as long as the parking for idle trailers without refrigerator units running, most of our 15-unit owners do not have a problem with the variance. Gary Turner's proven to the neighbors that they care about us. Lines of open communication provide us with report conditions that interfere with our daily lives. I would much rather have Turner Dairy as a neighbor than an extension of Overton Square that would greatly increase noise and traffic. I welcome you to visit my residence and back patio that backs up to Turner Dairy and see for yourself that noise is the least of our issues. Please consider that many of those with objections do not live next or close to the dairy, but claim they have issues blocks away. Many in the surrounding neighborhoods would love nothing more than to cause Turner Dairy to move and let Lowe's expand shops and entertainment to the Turner Dairy property. There are some people who do not care what the residents next to the dairy would prefer. They have their own agenda. Many who are leading this objection live blocks or miles away. I ask you to approve the variance with conditions that no trailer or semi-rig parking in this area is not allowed to have engines running strictly for parking purposes. Only Turner Dairy has worked with the adjacent property owners and spent hundreds of thousands of dollars on concrete fencing to be a good neighbor. Please be a good city administration and approve the variance. For anyone asking, Turner Dairy has not asked for this email, and they do not know I was writing it. But after the email blast to everyone and against it, I thought you should hear from those of us most affected by the issue, those of us who live next to the dairy.
We have the letter, and your time is up at this point.
Okay, thank you.
Responding. Thank you. Are there any questions of Mr. Bix? Hearing none, I assume that y'all are ready to discuss. Could I get a motion to approve BOA 20-94 as conditioned by staff?
So moved. Vice Chair, second.
All right, moved and seconded. Is there any discussion?
Yeah. Mr. Chairman?
Yeah, does somebody have their YouTube volume up? Yeah, okay, Miss Baker, did I hear you say something?
Yes, I would like to speak whenever it's appropriate.
Yes, go ahead.
Go ahead now, okay?
Yes, ma'am.
This is a really tough case for me. I have known people on both sides of this application for a very long time, and I have the greatest respect for them on both sides. I'm also very much appreciative of the landscaping and other improvements that the dairy has made to this site. Since I have been on this board, I've tried to make every decision on my vote based on the Unified Development Code regulations governing actions by the Board of Adjustment. So that is what I'm going to do today. This application does not meet the findings of fact in 9.22.2. It is an application for a use variance that requires findings of fact by the BOA that the subject property cannot be reasonably developed with any use permitted in the zoning district where it is located. In this case, multifamily uses are allowed in the C3 district where it's located with approval of a special use permit. Townhouses are permitted by right. Other than the dairy itself, the uses on all sides of the site are various forms of residential, so multifamily and townhouse seem to be compatible with the neighborhood. So I'm voting against this application today. That's it.
Okay. Thank you, Ms. Baker. Any other thoughts by anyone else?
This is Vice Chair Savage Towns. Quick question.
Yes, ma'am.
When they made the decision in 2016, what variances were they requesting at that time?
Mr. Whitehead, could you help speak to that?
Yes, the The only variance that was filed and actually acted upon was that fence height variance. But I believe there was Jeffrey. Yeah, there was a plan development application filed, I think, to basically address this back parcel, and that was withdrawn before, I think, before it even went to the Lands Control Board. Oh, page 21, Mr. Penza said.
Okay, so what we're deciding on today, this wasn't part of the rejection at that time of BOA, right?
The last time it came to the Board of Adjustment was, I think, in the 70s.
Okay.
Or before. 1984.
Okay.
Okay, any other questions or comments?
Can you this is Joy Doss. Can you tell me again? Where are the trucks being housed now? Did we say that earlier?
Yes, ma'am. The trucks are now within the industrially zoned part. While most of that is in closer proximity to Madison, to the left of the dairy building, there is that panhandle that is at the extreme northeast corner of the property. So there are some along that panhandle because that is also zoned industrial.
Mhm. Mhm. Okay.
Any other thoughts or comments?
This is Vice Chair Savage Towns again. Just want a point of clarity. So the trucks that are currently being parked or housed on the property, for lack of, or just highlight of the word, we're just basically moving them to the back part that's not permitted at this back portion of the parcel, which is not permitted at this point. Is that correct?
We're allowing that, and we're allowing the structure, the old gym of the JCC, to be used as a storage area.
Okay. Okay. Thank you.
And the storage area is for trucks and product.
Storage, yeah, the storage area is for, I think it's more dry stuff. Like, it's not finished product. It sounded like it was like cartons, you know, that kind of stuff like that. You know,
I'm just trying to get it under.
Yeah, go for it.
No, go ahead. You were saying.
Oh, well, I understand what Ms. Baker's saying, and I'm torn on this. On just, you know, I get her point. You know that, hey, we can't say this can't be used for something else, but you know it's got this gymnasium there. You know, and I think of that being part of the property, not just the, you know, there's a piece of land there. And with that, it makes this, to me, a little more unique in the where it sits. It has industrial that goes all the way to Jefferson to the east of it. So I don't know if it's that cut and dry, like, oh, we could put apartments there or something like that. I mean, I think that would involve, you know, changing kind of what's already in existence and on the ground. So I do think that is unique of what's currently there. But I don't know if that's enough or not. That's a hard call. I know we've looked at that in the past on things, but I certainly get and respect her point on it. But you go ahead, Ms. Doss.
Well, a couple of things. You know, I don't know what else it could be used for. Like you said, it is on their property, so I'm not sure. Technically on the property, so I'm not sure what else it could be used for other than just, you know, being there. But also, there's always a question when they start this expansion, you know, about, you know, being close to other people's homes, and also I don't fully understand it, is there going to be a situation with, waste, pollution, and that kind of stuff? So I'm not really clear on if there's
Say that last part again, Ms. Doss. I'm sorry.
like waste, pollution, and that kind of stuff. If there's a storage, it is closer to people's homes.
Correct. Yeah, absolutely.
Once you start putting them back, it gets closer to those homes.
Right. Any other thoughts or comments?
This is Portia.
Yes, Mr. Locke.
I'm also conflicted about this proposal. I do like the fact that they're moving some of the operations and storage back to the back where they're already entering and exiting the property anyway. And as far as truck traffic and just in general, as far as the area overall, with the expansion of the entertainment district, you already have expanded truck traffic to deliver goods and services to the businesses that are expanding there, the whole entertainment district. So do you let the company that's been operating there continue their truck traffic, or do you just invite others and let them expand and not the people who have been occupying that property for 80 or 90 years? And just wanted to, I guess, put that consideration there.
Right, okay. Mr. Jackson, did I hear you say something as well?
Yes, sir. I have a question for Josh. Just in reading this report, it says in the BOA in 1954 approved the request to expand the existing dairy via a parking lot expansion. And the Board of Adjustment approved that September 22nd of 1954. Okay? If that's the case, which obviously it is, we've stated it, does that not expand and make that property an accessory use to the dairy at that time?
Jackson, this is Josh White, Mr. Chairman. The geographic area of that 1954 case did not go this far north. In other words, in 1954, the subject property was still the JCC Community Center. Does that make sense?
Yeah.
Mm-hmm. Yes, sir.
So, in essence, then, let me ask you another question. From 1954 to present, there has been no BOA action on this piece of property we have in front of us today that would link the dairy with operations on that site. Is that correct?
That is correct. The 1984 case that we mentioned earlier was when it was under different ownership, and it was for an amusement event center to have unpaved parking.
So if that's the case, then help me understand, how is the dairy now using this property for accessory to the dairy? And are you saying they're doing that as a non-conforming use?
They have been instructed, and I think, as far as I can tell, adhered to this instruction. They are not utilizing the subject parcel. And again, I'm sure there's probably some minimal infractions, but those would not be permitted. They are not to be using that area because it's zoned commercial. And let me expand upon that. When the bar closed down and they purchased the property, they may have in fact utilized it as an accessory use, and then when that was brought to the attention of, code enforcement, that is generally when they retracted from utilization of this property.
Okay. All right. You answered my question, sir. Thank you. Mr. Chairman, thank you, sir.
All right, thank you. Are there any other questions or comments? Hearing none, I assume that you are ready to vote. Mr. Whitehead, will you give us a roll call vote, please?
Yes, sir. Ms. Baker, sorry.
Oh, no.
Mr. Claybrook.
No.
Ms. Doss.
No.
Mr. Malazri.
No.
Vice Chair Savage Downs.
No, I find that the standards of the UDC of 9.22.6 are not being met. It will be unduly detrimental to the properties in the vicinity. Thank you for that.
Ms. Skurlock.
No.
Mr. Jackson.
No.
And Mr. Chairman.
Yes.
We have 1 aye, 7 nays.
All right, sorry, the motion fails. Thank you all for all joining us today and giving your thoughts. Mr. Whitehead, will you call the next case?
Yes, sir, Mr. Chairman. That brings us to number 8, agenda number 8, which is docket number BOA 2096, located 297 Jefferson. The applicant is Binfield Investments, represented by David Bray. The use district, the CBD's district, and the request is a use variance from Section 252 to allow a non-conforming towing operation to reopen after a cessation of more than 365 days.
Okay, thank you very much. Could we get a quick staff report, please?
Okay, good afternoon, everybody. This is Teresa Shelton, Municipal Planner for Division of Planning and Development. This is a former tow lot located at 297 Jefferson Avenue. The request, as Mr. Whitehead stated, is a use variance from Section 2.52 to allow a non-conforming towing operation to reopen after a cessation of more than 365 days. Okay, go to the next slide, please. Next slide, please. I don't know if you can hear me. Okay, all right. Anyhow, it's in the Central Business District. After reviewing in accordance to the CBD district development standards, if they'll go to the next slide. Got a little delay going on here. Okay, hold on. Let me get to that. Exit, refresh. Okay, great. Thank you. If you can go back to the slide before this one, please. Thank you. There's, as you can see, there's a building here, office space, that faces Jefferson Avenue. The picture to the right is the current gate where they would access putting the cars or whatever they bring into the lot there, which is located toward the rear of the building. Next slide, please. This is the back fencing area for the building that you can see here, which, you know, if approved by the board, it would have to be replaced. This is a view from Jefferson Avenue looking northwest. Okay, next slide. This is the site plan that shows where they're at least wanting to store at least up to 25 vehicles at a time there. Go ahead to the next slide, please. All right. All right, just reviewing in consistency with Memphis 3.0, I got a summary from Mr. Ekstrom, Office of Comprehensive Planning. Just did a snippet of that. The application is a variance that lapsed during the COVID shutdown. The property has been used as a tow lot since 2009. The application does not meet the criteria of the Memphis 3.0 since the use is for a tow lot. This use does not fit with 3.0 future land use designation of anchor neighborhood urban accelerant. These uses do not correspond to the intent of the future land use map. The intent of this anchor neighborhood is for a walkable residential and mixed use district within a 5 to 10 minute walk of a citywide anchor consisting of block scale buildings with heights between 3 and 8 stories. While the district does not allow for occasional house scale buildings, a tow lot does not contribute to a walkable residential neighborhood and does not qualify as a mixed use. Next slide, please. Okay, my conclusions. The applicant is seeking relief from the subsection 2.6.3p of the Unified Development Code, which restricts tow lots from only being allowed in an IH or an EMP zoning district. The applicant is seeking a variance to allow a continuation of an existing nonconforming use in the Central Business District. According to Section 13-4-202B2C3 of the Tennessee Code, annotated after the adoption of the general plan by the legislative body, any land use decisions thereafter made by the legislative body, the respective planning commission or board of zoning appeals, when the board of zoning appeals is exercising its power on matters other than variances, must be consistent with the plan. Next slide. Okay, staff recommends rejection on this one. However, if approved, the staff recommends the following conditions. Any change or deviation from the site plan upon the determination of the zoning administrator shall be submitted to the Board of Adjustment for review and approval or administrative review and approval by the Division of Planning and Development. There should be a concrete panel fence installed on 2 sides, 5 by 5 by 4, around the trash rollout towards the front of the driveway on the side of the building, with 1 teddy bear southern magnolia and 2 white cloud mully grass to shield it from the Jefferson Avenue street view. All existing fencing shall be replaced with 8 feet concrete panels around the vehicle storage area. The gate entrance shall be replaced by a 5 feet concrete panel fence with an 18 feet wide double swing gate color coded in either black, dark green, or dark brown color coatings. Concrete panels should match the color of the existing building. There shall be 2 parking spaces in the back of the building for employees, and the driveway shall be repaved. Ladies and gentlemen, this concludes my presentation.
Okay, thank you very much. Are there any questions of staff at this time?
Mr. Chairman, I have a question of that.
Okay.
Is this a use variation of an illegal use that's there right now, or is this truly a non-conforming use that was legal when it was established?
Okay.
And is this variation? That's my question.
Okay. It was a non-conforming use, but however, I think at that time, the reason why they requested, they were trying to purchase in the middle of when we were out during COVID, to my understanding from the letter of intent. And somehow they didn't get a chance to beat the deadline, I guess, before the non-conforming expired.
Okay.
And Mr. Chairman, if I can piggyback on that, this is Josh Whitehead. What I'm going to do is while David Bray speaks, I'm going to search through the 1981 zoning code. I think where Ms. Baker was going is, was this ever permitted, at least going back to 1981, right? Because to be a legal nonconformity, you have to have been legal at least at some point, right?
Yeah.
And with that Mr. Chairman, I wanted to alert you and Mr. Bray that our person we anticipated that would call in opposition is not on the line, so it'll just be Mr. Bray as the sole speaker on this.
Okay, very good. Are there any other questions of staff before we get with Mr. Bray? All right, hearing none. Mr. Bray, are you with us?
I am.
Okay, will you give your name and address for the record for us?
Yes, David Bray with the Bray Firm, 2950 Stage Plaza North, and I also have the applicant here with me. You want to go ahead and get his name?
Yeah, let's go ahead and have him give his name and address as well.
All right, my name is Larry Rowland. I reside at 9226 Afton Grove, Cordova, Tennessee.
Okay, do you guys both swear to tell the truth, the whole truth, and nothing but the truth self you got?
I do.
I do.
Okay, thank you. Go ahead, and y'all have 10 minutes.
All right, thank you, and hopefully we won't use 10 minutes. It's been a lengthy meeting already.
Yes.
So as referenced with that question and how we got here, and the staff report references the fact that this has been operating under this use since 2009. Is in this business of towing, and was in negotiations with the previous owner to purchase the property. Had been assured by those at code that the use could continue, provided that he got that done within the 12 months of the previous owner closing business. So that process was moving along. COVID hit, it got delayed, and by the time he got to the point of going back to code enforcement and showing where he had purchased the property and was ready to get an updated use and occupancy permit, we were at 366 days or somewhere thereafter, and could not continue. And that's the basis for our variance on this. That's how we got to this point. As you read through the staff report, the staff report's going along and reading pretty well from our perspective until you get to Memphis 3.0. And agreeably, this does not match with Memphis 3.0. If you go back to the conclusion slide that was up just before this, it says you have to go by that plan, except in cases of variances, and that's what we're asking you for today. Is a variance so that he could continue on. This application never would have been before you if the COVID shutdowns hadn't happened and he had been able to complete this property transfer back in April and moved on. Mr. Rowland's here. He can tell you a little bit more about his business, how long he's been operating, what he's planning on doing in that area. And just for the record, and go ahead and get it on there. We're in agreement with staff conditions if you guys choose to approve this application. Go ahead.
All right. My name is Larry Rowland, minority business here in Memphis, Tennessee. I employ over 14 people in my trucking and towing business. The towing side, which I want to put here on Jefferson, the trucking I have on the industrial spot off President Island. This location here, we'd like to take it and make it better by agreeing with what you said between number 1 and 4. To do everything that you want us to do and follow code. Again, we've been trying to get this done for a long time now, and when we got to the code enforcement, hey, we exactly 5 days behind to get this legalized. DTS was at this location for going on 2009, and they actually had a U&O permit at this location. That's the reason why I purchased the property, to get it done. But again, when COVID hit, put everything behind everybody, the whole world shut down. So that's what we're here, spending the extra money trying to get everything legalized.
Okay, very good. Are there any questions for Mr. Bray or Mr. Rowland? All right, thank you, sir. And again, Josh, the opposition has not joined us, correct?
Yes, sir, that is correct.
Okay.
Wait, Mr. Chairman, we have breaking news.
There is opposition number 524-5108.
I think she's calling from a different phone number.
Okay.
So give me a second while we figure where she is on our deck. I do have an answer for Ms. Baker. Surprisingly, the codes chart from 1981 zoning ordinance does allow wrecker services in the CBD zoning district, so it was legal in 2009.
Okay, very good. So let us know when the opposition's here. Mr. Rowland, Mr. Bray, you're reserving 6 minutes, just so you know, to be able to speak to the opposition, not counting your, I think there was already going to be 2 minutes there just as normal rebuttal time. So that's, I guess, a total of 8 minutes you'll have if you need it.
All right, thank you.
Uh-huh.
All right. What's her name?
Jana Mitchell.
524 5000.
No, she called. She gave me 5108 524 5108.
Well, Mr. Chairman, we don't. She's not on the call.
That's it, yeah, that's it.
Apparently they found
Wait.
it.
No, that's Birch, Porter, and Johnson.
Yeah, that's the company. That's the company.
Oh. Thought you were Nathan Bix. Okay. We have, geez, Mr. Chairman.
Okay.
And what's her name, Jeffrey?
Jana Mitchell.
Ms. Mitchell, you're on the line.
Hi, yes, this is Jana Mitchell, 130 North Court Avenue. I am an attorney representing the Goldstein Family Trust, and we would like to go with the recommendation of the staff report of rejection of this application, as we agree that it is inconsistent with the Memphis 3.0 general plan. And I apologize, my number must be showing up from the general office number.
Yeah. Okay.
Nathan was calling in earlier, so we just thought he stayed on the line.
He just wanted to hang out with us for the afternoon. Are there any questions for Ms. Mitchell? Ms. Mitchell, I assume that the Goldsteins own property close to this property. Is that correct?
That's right. They own property their property line backs up to this property to the south.
Okay.
So they are between their property is a parking lot on Court Avenue, and it backs up. It's to the south of this property.
Okay. Okay. So is it
This is Vice Chair.
Yes, Ms. Savage-Towns.
Sorry, just quick question. Now, what is their opposition to the lot being there?
Well, we agree that it does not align with the Memphis 3.0 general plan. It's not aligned with the direction of the core of downtown, and it's just it is not amicable to what the surrounding area has, because the entire surrounding area is zoned CBD.
Okay.
The family, the trust, what is their property that's abutting that? Is that a commercial building or a business? What is that behind them?
Parking lot.
A parking lot?
Yes.
Okay. Thank you.
Thank you.
Any other questions for Ms. Mitchell? Hearing none. Thank you for joining us, and sorry for the mishap with the number. Our apologies. Mr. Bray or Mr. Rowland, we're going to move back to you. You have, what do we say, 8 minutes if you need it. Would you like to respond?
Yes, please. Can I get the staff to put up page 7 of the staff report?
Hold on. I don't think they have that. Hold on.
David, we used to have our PowerPoint running on the YouTube, but all the board members have the staff report.
Yeah, I'm looking at page 7.
Okay. So page 7, you can see our subject property highlighted with the star on it. It's the darker shade of red. The opposition was calling in. They have the property immediately to the south of it. I think another property, if I go back to the vicinity map, is scattered in there. We don't take issue. I agree that the staff has the correct interpretation of Memphis 3.0 for this area. But if you look at this block, it is dominated by parking lots. There's not a portion of this block that is consistent at this time with Memphis 3.0. And the recommendation is that this less than 0.2 of an acre parcel should be the starting ground to start implementing 3.0. And I realize, of course, that it has to start somewhere, but there are other tracks that would be a better starting point to get there than this tiny little track in the sea with a bunch of parking lots. So that's why we're seeking relief from this board. And as the applicant stated, he missed by 5 days, which I'm sure everybody on the board can sympathize with. Most things in life in this last year have been delayed by more than 5 days.
Yes. I actually, like I said, I've been running the towing service in this area for going on 10 to 12 years, and their parking lot has not been used. I know for the last year and a half, probably longer than that. So, the opposition, I understand what they're trying to do to keep the value so far and so on, but I'm actually trying to bring jobs in the area, a minority business at that in the area, to get on with the city rotation so far and so on.
Okay, thank you, Mr. Rowland. Are there any questions of Mr. Bray or Mr. Rowland or staff? All right, hearing none, I assume y'all are ready to discuss if we can get a motion to approve BOA 20-96 as conditioned by staff.
John Jackson, so moved.
Is there a second?
Second.
All right, thank you. Anybody have any immediate thoughts on this?
Mr. Chairman, Mary Baker,
Yes,
I have
ma'am.
a question.
Go for it.
Is there any way that this thing could be approved with a time limit? Because, I mean, it is true that the good fortunes of downtown hadn't gotten quite here yet. But at the same time, once this thing's approved, it's there. And you never know. Some of these establishments can operate in a reasonable way, but others become a lot of times a problem in the neighborhood. So you just don't know with this particular one. Anyway,
what time limit would you suggest?
Well, I mean, I don't know. 5 years? Would that be too much? It'd just be an opportunity that if it turned out to be something we wish we'd never approved, but we couldn't take it back, but there would be that opportunity to
relook at it.
Yeah.
This is Vice Chair Savage Towns. I think I'm not in agreement with that unless we have put that kind of clause in the other. We have parking lots. Sorry, my feedback. We have parking lots nearby, and so to put in for the tow lot, a sunset clause in it when we don't have that, because you're going to still have the parking lots in that same vicinity. So if we're talking about the appearance of downtown, I don't see how that changes that.
This is Carson. I've got a comment as well.
Go ahead, Carson.
So he closed. He purchased his property, correct?
Correct.
Yeah, I can't agree with a timeline on someone that owns the property fee simple. Now, if the good fortunes of downtown make it to this area, then it's probably going to be in his best interest to sell the property to somebody that's going to use it for a different use, because the value of his asset will likely go up dramatically.
Right.
But I kind of agree. It's surrounded by nothing but a sea of asphalt right now. The use next door has a roll front door, so it looks like somewhat of an automotive use. And you know, I have been affected in my personal business by this virus and timing, so I have some sympathy with what he's talking about.
I would agree with you, Carson. I think for me the most positive thing on this case is kind of the timing of it all. We're so close to where we wouldn't even have to be here, and I know enough in my business of the things with commercial transactions that have all been delayed, and so we probably wouldn't be here if not for the COVID, and that's just something that the code doesn't really talk much about COVID, but that to me is a very unique circumstance that's happened this year. So I'm not necessarily, I see what we're talking about with a sunset on it, but I just kind of relate back to like, man, we're talking about 5 days that we missed it because it's something kind of beyond our control. So I wouldn't necessarily be in favor of that on this particular case with these facts. Any other comments? Hearing none. Ms. Baker, do you want to put another motion for a time limit out there, or do you want to drop the time limit and us just vote as we...
I was just floating it out there to see if
Sure.
any of the other board members thought it was a good idea. But
well, and that's why we discuss these things, you know, so nothing wrong with that. So with no other comments, I assume y'all are ready to vote. Mr. Whitehead, will you give us a roll call vote, please?
Ms. Skurlock.
Yes.
Mr. Malazri.
Yes.
Ms. Baker.
Yes.
Mr. Jackson.
Yes.
Mr. Claybrook.
Yes.
Ms. Doss.
Yes.
Vice Chair Savage Towns.
Yes, provided the standards of 9.22.6 of the UDC are being met and will not be unduly detrimental to the properties in the vicinity.
And Mr. Chairman.
Yes.
8 ayes.
All right, gentlemen, you're approved. Ms. Mitchell, thank you for joining us. Sorry we couldn't get you in any quicker. Mr. Whitehead, will you call the next case for us, please?
Yes, sir, Mr. Chin. Agenda item number 9 is docket BOA 2097, located at 2240 Covington Pike. That's at the northeast corner of Covington Pike and Elmore. The applicant is Herbis Systems, represented by Kenny Crenshaw. The use district is the light industrial EMP district, and the request is a variance from paragraph 49782 to allow the reuse of a sign after a cessation of more than 365 days.
Okay, thank you, sir. If we could get a brief staff report, please.
Yes, sir, Mr. Chairman. Our staff planner on this is our intern, and he's in class right now. So again, I will do a presentation.
Okay.
As I mentioned, this is at the northeast corner of Covington Pike and Elmore in our one of our automobile rows. This is a sign on-premise advertising signs are treated like all other uses. They can go vacant for up to 365 days and be reused without any action, any zoning action. Once you cross that 365-day period, they cannot be used. In that way, signs are really treated by the code as non-conforming uses versus non-conforming structures. Just a little zoning 101 for everyone. A non-conforming structure can be vacant for forever as long as it's not destroyed by an act of God by more than 75% of its value. So the fact that we assigned signs as non-conforming uses kind of speaks to the intent of the sign code, which is we wanted to encourage signs to be shorter, smaller, further from the street as it compares to the previous sign code. As I'm sure anybody who has been in Memphis for any time, they noticed that at least for some time period, our sign ordinance was very lenient, and that's not as lenient. So, Mr. Zena, if you could advance the slide. We are recommending rejection on this case because we feel that the sign, this is a great opportunity to get the sign more in compliance or totally in compliance with the ordinance. The sign on the left shows the previous user, Thrifty, car sales, and on the right, the applicant before us, Herbis Systems. They would to reuse the structure and the sign face. Mr. Chairman, the conditions, we're recommending rejection, and then we've crafted some conditions, but quite frankly, these conditions are basically bring the sign into compliance with the code. So if a board member is inclined to recommend or vote or make a motion of approval, we're going to have to do something to these conditions because right now there's not much difference between a rejection and approval with these conditions, because these conditions essentially bring the sign into compliance, which a rejection would as well. So with that, Mr. Chairman, I'll relinquish the floor, and I'm available for any questions.
So let's talk about these conditions.
Excuse me, Mr. Chairman, am I allowed to speak at this time, or do you want to?
Not yet. Not yet. We'll get to you, though. Yeah.
Okay.
Tell me what, so I guess explain to me, I'm trying to look at this report and see what's there with the sign now and what it need. Explain to me what the sign should be. How about that? A little bit better.
So condition number 1 says the sign should be lowered to 35 feet. The sign currently is 45 feet. Condition number 2 says it should be set back 10 feet. I think it appears it's closer than 10 feet to the back of sidewalk. So those would be the 2 conditions we would need to really focus on if we were going to approve this as it is or kind of it is.
Okay. All right. That helps. Are there any other questions of staff before we move on to the applicant? Hearing none. Was that Mr. Roberts that I heard?
Yes, sir. I am Jerry Roberts, and we are the contractor. I have a current...
Go ahead and give me your name and address, and I'll swear you in, and then we'll get to the rest.
Okay.
Or give me your address.
My name is Jerry Roberts. I live at 2361 Brook Hollow Cove in Memphis, Tennessee.
Okay, perfect. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. We also
go
have
ahead.
Crenshaw, who is here, who is the actual individual whose photo is on the sign. But he is the owner of the business, and he wanted to have some remarks also.
Do you want me to go ahead and swear him in, is what you're asking me to do?
Yes, sir.
Okay. Mr. Crenshaw, can you give your name and address for the record as well?
It's Kenny Crenshaw, 9416 Brunswick Road, Millington, Tennessee, 38053.
Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, gentlemen, proceed on.
Okay. Well, let me give you a little bit of a timeline on this. We were awarded this job in the middle of April, and we got everything set up to go on it, and I submitted a permit application on May 6th to Construction Code, the sign department. And then we were proceeding on because in a situation where you're doing replacement faces, it's never been an issue that you're not allowed to do these. In fact, you discussed the Prairie Farms or the Turner Dairy earlier. When Turner Dairy was changed to Prairie Farms, we changed the faces out. Even though the sign was a non-conforming, they were an operating business. And in that section there, section 4.96I, you are allowed to change out faces in a non-conforming sign as long as you do not increase the degree of non-conformity. I did not realize that this was a non-conforming sign, but we submitted the permit application on May 6th, And 2 weeks go by, and is when I received the rejection, and it brought up the fact that it was a abandoned sign. And again, I've had a license since 1979. I had never heard the term abandoned sign. I called 2 other sign companies in town and I asked, have you ever heard this before? And they said no. Well, then one was eventually, they had to file a variance on replacement faces, and they were awarded it because, yes, the sign was non-conforming. It was too close to the sidewalk, and they said, yes, you have to get a variance, and they were granted this variance. But in this particular case, I did not know of this term abandonment, nor did I know that anything longer than 365 days, I think you were supposed to remove the sign. And in this particular case, a letter of abandonment, I don't know if one was ever sent to the property owner who maintained a guard on the property 24 hours a day for safety aspect. So having said that, I thought it was an easy thing to get a permit. So after I received this rejection notice from Felicia Campbell, I called Rose Hill, who was the manager of the sign department. And I left several messages. I kept getting a phone mail. Finally, around the first week of June, I called the sign desk and I said, is anything wrong with Rose Hill? Because I keep getting a voicemail and she's not returning my call. And they said, yes, she retired in March. And I said, well, why is it that you did not notify the sign companies that this individual that I've known for 30 years and worked with had retired? So I guess a lot of this goes back to the fact we're not allowed to go into construction code, nor are we allowed to really talk to so many people in person due to the COVID. So this is why we're here. We're asking that since the sign has been termed abandoned, and there's not been a letter of abandonment that I know of, and the sign is still there, and we're not increasing the degree of nonconformity, that we be allowed to change out the faces, remove the pole covers that look terrible. A pole cover is required on a sign if the poles are 18 inches or less. These poles are 24 inches in diameter, so they are within ordinance to just repaint the poles and remove the hideous-looking pole covers. Having said all that, we are asking that the sign be approved as is. Mr. Whitehead brought up the fact that it is too close to sidewalk. I think it's 20 feet from the sidewalk, and code says 10 feet. So I think it's within the distance that's allowed for the setback, which it's 10 feet, and I do think it's around 20 feet to the back edge of the sidewalk, and to the curb it's at least 26 or 27 feet. Mr. Crenshaw would also like to discuss.
Okay, Mr. Crenshaw.
Yeah, thank you very much. Hey, I appreciate y'all hearing us. We've been in Bartlett for 35 years, and we're making the move to Memphis. We bought a distressed property, and we feel like we're making a lot of improvements on it. And one of the reasons why we bought the property is for the sign, because we advertise a lot. The Let Me Kill Your Weeds brand is known everywhere, and we're just simply asking to, I guess, make the one variance, which would be on the height. We're in full agreement on, the setback from the road, and also we haven't done the landscaping yet. We haven't quite finished the improvements yet. But, the sign's pretty typical of what's on Covington Pike. And, right next door you can see the McDonald's sign. It's as tall or taller. So there's a lot of signs like that on Covington Pike. And I understand that, that maybe that may not be the best thing in the future, but we would rather spend the money on landscaping and doing, whatever the city requires us to do around the sign. And we put up a new fence and taken down a lot of things that look really bad. And so, like I said, we would like for the sign to remain the height that it is, so we don't have to take it down, and we would, rather dress it up in other ways if the board so approve. Thank you.
Are there any questions of the applicant at this point?
This is I don't know necessarily for the applicant, but how many days were they beyond the 365-day threshold?
Madam Vice Chair, this is Josh Whitehead. When you asked that question, I was looking on Google Street View, which I am assuming is what Felicia Campbell, the permit person on this case, probably did. And I have gone back to June of 2016, and Thrifty had closed at the time. So it's been at least 4 years that the previous business had closed. And that's how the code, I'm reading at section 4915 F1C1. It speaks to a determination that if the business goes away for 365 years, the sign that's what when a sign is abandoned. So it's been several hundred more days than 365 to answer your question.
Mr. Whitehead, could you also expand a little bit on just the whole idea of an abandoned sign? Is this something that's newer under the new UDC? I mean, I'm familiar with the concept, but we always hear the variances. I could see where possibly, I don't doubt that Mr. Roberts hadn't dealt with it before, just in what he does. But is this something that's, we've heard a lot of them in the past couple of years, but were we hearing cases like this 20 years ago?
You're correct in your assumption. It'll take me a minute to get the exact date, but I would guess that this section of the code was added maybe about 4 or 5 years ago. So yes, it is. It's a relatively new section of code, and it was meant to aid, to add some direction to the sign permit folk on when a sign loses its protected non-conforming status.
Mr. Chairman, this is Jerry Roberts again.
Yes, sir.
I wish that we could, in our industry, could find out this portion of the ordinance, so that if we had known something about this, we could have made adjustments for this. But as Mr. Whitehead said, if it's been within the last 4 or 5 years, and again, I've talked to 2 different firms, and none of us had ever heard of this term abandoned sign. And I understand, I'm old enough to realize that ignorance of the law is no excuse. And I'm certainly not saying that I'm right, but again, all we're doing on this site is changing out the faces. It's not like that we were adding signage. You're allowed 300 square feet there, and what we're doing is 250 square feet. So we're well below the maximum. We're not adding anything, nor are we increasing the degree of nonconformity. So this was the point that I didn't think we would ever have a problem.
Okay. Mr. Whitehead, remind me again, did you say that the sign as in its existence now is 45 feet or just 40 feet?
45. And have an exact date for you. This section of the code was adopted and became law in December of 2017.
Okay. Okay, so this sign as it is 10 feet too tall, and we're not really sure on the setback, right? To know if it's 10 feet or not.
It looks 10 to, it's definitely 10 or based upon, comparing distance between the back of the sidewalk and the curb, which is 10,
Sure.
and the back of sidewalk to this sign. So it's definitely 10.
So our issue really is the 10 feet of height.
Yes, sir.
Okay. All right. Any other questions of the board, of staff, or the applicant?
I have a question for the applicant, Mr. Chairman.
Yes, go ahead.
Mr. Applicant, Mr. Roberts or Mr. Crenshaw, the way we have the one condition that looks like that may survive this discussion would be the requirement to add landscaping at the base. how do y'all feel about that?
Oh, that'd be fantastic. You know, we've added, we removed the entrance off of Covington Pike because it was dangerous, and we left the entrance over on Elmore, and we are going to landscape. I don't know who the gentleman was with the city, but our contractor is Chris Woods Construction, and we actually took down some diseased trees. There were some Bradford pears that just looked horrible, and we took them down, and the gentleman with the city told Chris Woods that we would need to deal with that and put them back, and we just have not done that yet. But I don't think they're going to give us our full approval from code enforcement until the landscaping is dealt with. So we have every intention of doing that, and we'd be glad to do that.
Thank you.
Okay. Any other questions of staff or the applicant? All right, and Mr. White, again, there is no opposition on this case, correct?
Sorry, I was talking to Jeffrey.
Oh, there's no opposition, right?
That's correct. Yes, sir.
Okay. All right, with that, then I assume that we are ready to discuss. Can we get a motion to approve this case as conditioned by staff?
So moved, Vice Chair.
Okay. Moved. I think I heard a second as well. So let's. I'd like to lead the discussion in talking about these conditions. It seems like we could leave number 2, but it might be moot. It looks like it's over 10 feet. It definitely looks like it's far enough. I would vote to remove that condition. And I would be, based on where this is on Covington Pike, I know we got to start somewhere. I just don't see that area changing too much in the next 25 years. I would also remove condition 1, but wanted to know what y'all had to think about removing those 2 conditions from this approval.
I would agree, Mr. Chairman.
You would agree? Okay, so would the person that moved this first be willing to change their movement to remove conditions 1 and 2?
So moved, Vice Chair.
Okay, and our second?
Second, Carson.
Okay, very good. Is there any other discussion on this particular case? All right, hearing none, Mr. Whitehead, will you give us a roll call vote, please?
Yes, sir, Mr. Chairman. Mr. Jackson.
Yes.
Mr. Claybrook.
Yes.
Ms. Doss.
Yes.
Mr. Malazri.
Yes.
Vice Chair Savage Towns.
Yes, I find the standards of 9.22.6 of the UDC are being met and will not be unduly detrimental to the properties in the vicinity.
Ms. Baker.
No.
No. Ms. Scarlock.
Yes.
And Mr. Chairman.
Yes.
7 ayes, 1 nay.
All right, very good. The motion is approved. Thank you, gentlemen, for coming down, talking with us today, and good luck with your new venture there. Mr. Whitehead, will you call our next case today?
Yes, sir, Mr. Chairman. 2 more. Agenda item number 11 is docket BOA 2099 in the county. The location is the west side of Macon Hall Road at Macon Oak Road. The applicant is Jim Etheridge, represented by Cindy Reeves. The use district is the Sag Conservation Agricultural District with a planned development overlay that assigns the R6 zoning regulations to the property. And the request is a variance from subsection 331B to allow a lot without road frontage.
Okay, very good. Mr. Whitehead, I assume that you're going to present this for Mr. Penzis, is that correct?
Yeah, Mr. Penzis he's fallen asleep, it looks like. So this is, as I mentioned, this is out in the county. This is in the Woodland Hills planned development, which is the large, mostly single-family residential area that was built on the old Holiday Hills Country Club, I believe. And the country club building along Houston Levee is now a church, I believe. The slide right here shows the triangularly shaped parcel that is owned for single family, and I believe that is the intention of the applicant to develop it as a single family property. Next slide. This property is surrounded, I believe, on all three sides by common open space. Open space which was designed as part of this subdivision to provide a network of pathways. The applicant has received approval from the Homeowners Association, which has control over all common open spaces, for an easement to pass over this common area, but that easement does not grant a zoning variance, which is why we are here today. Next slide. And here's a couple views of the property. Well, the property's on the right, on the left-hand side, and on the left on the right-hand side. Again, more views of the subject property and its surroundings. Next slide. And here is a site plan that shows that proposed access to the property. Mr. Chairman, we have a very open constant in the office now, which does not lend itself to telephonic board meetings. And next slide, we are recommending approval for this request. Again, this is a request to allow a lot without road frontage, and in the past, basically attached one primary condition, which is an access easement shall be provided so the property can develop. With that, Mr. Chairman, we do have several callers in opposition to this case, but I am available for any questions.
Okay, are there any questions for Mr. Whitehead?
Mr. Whitehead, I have a question.
Yes.
Did you say that the Homeowners Association had approved this?
Yes, I asked Mr. Penzis that yesterday, and he said that they have in hand the easement agreement. Yes.
Okay. Any other questions?
But Mr. Chairman, I think if Ms. Baker wouldn't mind, we probably need to get that on the record from the applicant as well.
Okay, very good. Any other questions of staff? All right, then we're going to move on to the applicant. Is Ms. Reeves on the line with us?
Yes, Mr. Chairman. Cindy Reeves, SR Consulting, 5909 Shelby Oaks Drive, Suite 200.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, and do you want us to go ahead and get Mr. Etheridge, or are you going to do most of the talking here, you think?
I will be doing most of the talking here, I think.
Okay, then go ahead, if you'll go ahead and share with us.
Okay. Thank you, Mr. Chairman. As you can see by the site plan, it's an extremely unusual parcel. It was created because of a blue line stream to the north, a 400-foot MLG&W easement to the west, and common open space. The common open space was intentionally put in place to allow pedestrian access for the entire neighborhood to be able to walk to the Macon Hall School and utilize walking around the lakes and the trails, using the trails. So it benefits the entire neighborhood, which is approximately 500 homes. And the walkway is a really good amenity of the subdivision. When they did this triangular lot, it was not a part of the Gardens of Woodland Hills subdivision. So all you had was common open space. And if they would have known at the time that because of the MLG&W easement and the common open space and the blue line stream, that would create this unusual lot, they may have at the time created a flag lot that would have taken the access out to Macon Hall Road instead of getting the egress easement from the Homeowners Association. So they have an egress easement that was done from the association back in to 2005. So that allows them access to their lot. Let me get back to where I was. The land is available. There's very few lots available in the county. This lot will be able to be sewered because of where it's at. Because of the recession, because the recession has gone, and we've come out of the recession, there are very few lots left. And Mr. Etheridge has been approached by someone to build one single family home on this land, and it's a very large lot. It's almost an acre or a little over an acre. And we feel that that is the best use for this property, and that it would put it on the tax rolls and put another new home in the neighborhood, and it would be a benefit instead of just having the vacant land there that Mr. Etheridge owns and pays property taxes on. We feel that that would be a much better use for this, and I would like to save the rest of my time for rebuttal.
Okay. Well, you have 7 minutes and 15 seconds for rebuttal.
Okay, thank
not to mention the 2 minutes that come with the rebuttal. That's 9:15. Are there any questions of Ms. Reeves? All right, with that, we will move to the opposition. Looks like first up is Mr. Ron Williams.
Mr. Chairman, he has not made it to the call, but we do have Ms. Kathy Williams.
Okay. Ms. Kathy Wallace?
No, it's Wallace, yes.
Yeah, okay.
Mr.
Can you
Williams
give
is
your
my
name and
next door-
address for the record?
Yes, it's Kathy Wallace, 1235 Macon Hall.
Okay, and do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, go ahead, share with us.
Okay. Well, first of all, she said a couple of things that I'm not quite sure of. They've been building all this time. There's been no recession over here. We've got a whole new neighborhood, but it's not over an acre. It's under an acre. I'm looking at the property, and this property is directly behind my house, and it is an open area for this whole neighborhood that I've been here over 10 years, and most of the people around me have been here even longer. Many of us senior citizens, we walk, we use this property. The kids use it. The dogs play in it. The ducks, the geese. This is a very, they're right, it's a very beautiful lot that someone you might think would want to live there, but they're going to be stuck out in an island blocking all of our views of the lake, blocking our fountain that we paid to put into that lake so that it would have a very aesthetic look, and that people could come and have a peaceful place to gather, to, hang out with their families and enjoy. It's the only place they've literally developed 500 houses in this neighborhood, and probably close to 100 of those in the last 2 years. They've taken up every space we have, Mr. Etheridge, and now they want to take this one last little space that our HOA, I don't know who told them that we approved this. I'd like to see that, because I've been talking directly to the HOA president, and she has not mentioned that whatsoever. But we have spent thousands keeping this lot up. We mow it. We spray it for weeds. We had to put in a drainage system because it floods. That the north side of that lot is a ditch that all the trees are falling into. It's eroding into that triangular lot. So I don't know what they plan to do with that. They'd have to build up this whole land, and if they did, that would push the water into myself and my neighbor's yards that we've already had numerous issues over and had to pay God only knows how much to keep it from flooding our yards, which are already washing away. But we've done all this to keep this property up, and he's paying $100 or something a year for taxes. And I'm sure, for that matter, I personally paid the $100 if that's all this is about. But we were all given the impression we moved this, that this area would be open for families forever, that there was never any mention of there might be one house stuck right in the middle of it. There would be no boundaries unless they put up fences, and then that would block everybody from going to the lake, from sitting. We have people sit out here and do yoga
under the trees. They come with their families and have picnics. And he's wanted to take all that away from us for one lot. And I'm speaking, I have spoken. They sent out letters that hardly anybody got. Like I said, I live on here and I'm retired. People and their pets and their families are out here every day of the week using this property. And now he wants to take it away, and we won't be able to, there will be nothing. And what they don't show you is that driveway will have to come right in between that ditch and my neighbor's house. It's blocked by trees, so if somebody pulls in and out of it, it's easily going to cause wrecks. You have kids riding bikes, playing up and down this pathway, and then now you're going to have cars driving down through in between. It's probably 30-something feet there. I don't have the exacts. I'm not a lawyer. I'm doing this all free-handed. But they're going to put a driveway right in the middle of the access to this. And then, again, there'd be no way to know the boundaries unless they put up a fence. And that would block all of us from using the lake, the fountain that's out there to be soothing and comforting to people. And I just don't see this one lot that he wants to take away so much from a whole neighborhood, and it'll be just stuck out there. We've planted trees. I'm looking at a pecan tree that I've babied for 5 years to get to grow so that we'd have more shade and more space to enjoy. That's all I'll say. And, the like I said, it floods. I'm looking out there right now. It's water an inch or two deep in that area. So that means he would have to build it up. And that's going to push that water into our yard at that point because we're that close. I mean, I could walk out and touch it. And I just don't see that it's a good thing for our neighborhood. They've put 500 homes in here. I don't think they need one more. I don't know what else to say. I mean, I've talked to every neighbor that walks through here. They didn't get letters. Nobody was prepared. They can't get off work to get on these calls. But there's not a person in this subdivision that thinks that would be a good idea.
Mr. Chairman?
Yes.
I think Ms. Wallace provided us a good segue. We have 3 additional people, and I just wanted to remind Ms. Wallace that the 10-minute is cumulative.
Okay, go ahead. Yeah, I'm good. I'd be glad for them to speak.
Okay,
are there any questions of Ms. Wallace right now? Hearing none, and we have a little over 5 minutes left, and we can move on to Mr. Shelby.
Well, Mr. Williams is with us now.
Oh, Mr. Williams is back, or
well,
here.
He's here. He never left.
Mr. Williams,
hello.
Can you give your name and address for the record?
Ronald Williams, 1225 Macon Hall Road, Cordova, Tennessee.
Okay. Do you swear to tell the truth and nothing but the truth, so help you God?
I do.
Okay, go ahead, sir.
So I've been at this residence for shortly about 5 years, going on 6. One of the things purchasing this home was the view. When you walk in the house, you see the back view, you see the pond, the common area. With that being said, it is beautiful. People use that walking area. I don't know how adding another home in that area would be safe, because now you're adding potentially a driveway next to a walking path where kids on bicycles, are riding. To me, it's adding a danger that we don't need for one home. I too, like Miss Kathy, I'm not aware of the HOA approving this. We didn't hear anything about it. It wasn't anything that was presented to us as members of the HOA. So I would also like to know, when was that approved and who approved it? And it's just that, people use the pond for fish in the community. All the residents, that's in the surrounding areas from my home also backs up to the pond. And, people use it to fish. They fly kites. have picnic areas, and they do this when it's not flooded, right? Because we do have a issue with the grading of the grounds, and we have paid, a few dollars to make sure that it doesn't always flood our yards. The walking path has just been resurfaced. It still has issues. I believe that the developer knew what they were doing, and it wasn't correct. I think they cut corners, and the residents in that area is paying the price for it. And adding another home, I don't think is beneficial to the residents in the subdivision.
Okay. Thank you, sir. Are there any questions for Mr. Williams?
A quick question, Mr. Williams. Do you and your neighbors pay dues into the homeowners association?
Yes, ma'am.
Thank you.
Any other questions? All right, hearing none, is Mr. Shelby with us?
Hello.
Yeah, Mr. Shelby, how are you?
I'm doing just fine. How you doing?
I'm doing good. Hey, you'll give your name and address for the record.
Okay, and I have a real estate agent here with me as well, just to kind of give his insight. So if he can be allowed to give his
y'all
input.
both give your name and addresses then.
Okay. Brian Shelby, 1243 Macon Hall Road.
This is Alan Keaton, Keeton. I'm a realtor with Crylike and sold this house to Brian 16 years ago.
Okay. Do y'all swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
We do.
Yes.
I do.
Okay. All right. Just so you know, I have 2.5 minutes left, and there's one other person that may want to speak. So just go ahead.
I'm just in agreement with what Ronald and Kathy had to say about this. It just seems like it's a lot for such a little, just one particular family. But if this was something that was voted on in 2005 or approved by the HOA in 2005, it seems to me like it would make more sense to have an approval now at the point we're dealing with this issue, especially when there's so many homes involved, so many families. I just think that's the first I've ever heard of it. And I bought my home in, I believe it's 2004. But it doesn't make a whole lot of sense to me. And I concur with everything they have to say. And I think Alan has something to add also.
All right, Mr. Keaton?
Yes, we want to leave time for the other person to speak too. Just looking at
a minute and a half.
Okay, looking at the diagram of the plat of the property with the sewer line, it looks like it would cut the size of the lot down considerably, and it seems like you ought to consider what kind of a house is going to be put on the property and the views that these neighbors are going to see. And I yield the time to the next person.
Okay, thank you, Mr. Keaton. Are there any questions for Mr. Keaton or for Mr. Shelby? Hearing none, then we're going to move on to Ms. Jeffries. Ms. Jeffries, are you with us? Hello, Ms. Jeffries.
Mr. Penzis believes we may have lost her. Let me check real quick. Mr. Chairman, I think we've lost Ms. Jeffries between the time we started and now.
Okay. Does anybody else with the opposition wish to take up the last minute or so? Hearing none, we're gonna move back to the applicant. And so the questions, just offhand, I'd love for Ms. Reeves to address are, tell us a little more about the HOA easement, and could you explain a little more about why this property wasn't already platted at the beginning? It looks like Mr. Etheridge was the one that developed the property back in, the 90s or something like that. I'm looking at the plat right now. But if you could address that, and you have 9 minutes and 15 seconds.
Thank you, Mr. Chairman. The easement and instrument numbers are shown on page 14 of the staff report, and they were signed by the HOA in May of 2003, and it was recorded in March of 2005 to allow Mr. Etheridge access to his land. That land was not included in the lakes of Woodland Hills, the gardens of Woodland Hills. And so when the land eventually got platted, it was in another phase. They didn't realize that they had unintentionally landlocked it by having the common open space on both sides and the MLG&W easement on the other side. So that's what created it. Once they realized that, they got egress to it so that they could use it at some point one day. We're not in a recession now. It's taken over 30 years to develop this planned development, and the property was never, the triangle that Mr. Etheridge owns was never really intended to be used by the neighbors as part of their common open space or taken over by the neighborhood as common open space. And we didn't think that that was the intention, that they felt that the land was theirs. So when it did get platted, that's when they realized that they had the issue. So I hope that answers your question about the platted and the easement. They're using property that does not belong to them. The flooding is not on the property that they had fixed a couple of years ago. That was in the 50-foot common open space, and Mr. Etheridge actually contacted a contractor to give them a better price to fix their flooding issue. We're not taking away anything because it always belonged to Mr. Etheridge. We're not trying to take anything away from the neighborhood. We just want to add another home that can be a part of the neighborhood. And they'll also be a part of the neighborhood association. So I don't think that the trees that they planted are on this lot. And if they are, they definitely did not ask to plant them on the lot. So I'm not really sure where the trees are. And if this lot gets approved, then the drainage will all be graded to go towards the lake. It will not be graded to go towards the home. And they will not be creating a drainage problem because they will have it engineered in order to make sure that there's not any drainage issues, and it may possibly help what drainage issues that they may still have. So a question for the realtor is, whenever I get a chance, is when he sold the house, did he sell it as a lakefront home and say that it was never going to be, nothing else was ever going to be on Mr. Etheridge's land? And, that's sort of concerning because we definitely did not think that that Mr. Etheridge's land has ever been represented as to being a part of the common open space and belonging to the homeowners association. It's always been his intent, once he was getting close to being out of lot, to actually include this lot in the planned development and to make it a new home there. So I am here to answer any other questions that you may have. I don't want to belabor this, so I appreciate your consideration, and I'm here to answer questions.
All right, are there any questions for Ms. Reeves right now?
Mr. Chairman, John Jackson.
Yes, sir.
Ms. Reeves, if the intention of this was not, if the intentions of this was not to be open space, okay, then what was the intention of it to be?
Once he realized that it was landlocked, That's when he went to the homeowners association to get the ingress egress easement so that it could be a lot. And the way that the platting was done, this land was not platted until way after the gardens of Woodland Hills. So they didn't realize that they were creating this problem, because they were just taking and there is actually an outline plan that shows all the common open space, and it does not show Mr. Etherson's land being a part of it, and it was clear that it was going to be a part of parcel 9 and not a part of parcel 1, which is what Sargent is.
And you say
platted way later than the gardens plat got recorded.
And you say it's clear on the overall outline plan that this was to be a lot?
Yes, sir, it is. And that's shown on plat book 263, page 35 is one of the outline plans. Also, Mr. Etheridge was not the developer of the gardens of Woodland Hills. The developer was David McAllister. And so Mr. McAllister did not own Mr. Etheridge's land, which is another reason that it was an oversight that there was going to be this remnant of landlocked land. And once they realized it, that's when they went to the neighborhood to get the ingress egress easement so that they could access it. If they would have known, they may have even approached the neighborhood association to make it into a flag lot, which would have been another option, but at the time nobody really thought about doing a flag lot there.
Hey, Ms. Reeves, so the Gardens of Woodland Hills, is that the property immediately to the east of this or the property to the north? I'm just trying to make sure I got my neighborhood straight.
It's immediately to the east, and it's where the opposition lives, which was developed by David McAllister.
Well, Mr. Etheridge signed the owner certificate on the plat.
Because David McAllister purchased the land after the plat got recorded. David McAllister was the developer, and until he finished developing the land, Mr. Etheridge owned the land.
Okay.
He was the land owner, and David McAllister was the developer.
Okay, I see what you're saying. Any other questions of Ms. Reeves?
Ms. Reeves, this is JT. I just wanted to make sure that I understood all this correctly. So the parcel that's in question has always been owned by Mr. Etheridge, and the ingress and egress easement that he obtained, that was common open space, and he obtained that ingress easement from the homeowners association. Is that all correct?
That is correct. He obtained the ingress egress easement from the homeowners association because that was common open space, and they granted him the easement so that his land was not landlocked and he would have access to it. What they didn't do, and probably should have, was make it a flag lot instead of letting it continue as a landlocked piece of land. The intention was always to build on it. It's a much larger lot than the other lots in the neighborhood. It's an acre lot because of the sewer easement connection. They'll place the home in a good location.
Thank you.
Any other questions? Hearing none, I assume you guys are ready to discuss internally. Is there a motion to approve BOA 20-99 as conditioned by staff?
John Jackson, so moved.
Is there a second?
Second.
All right. Any thoughts on this from the board?
This is Portia. I do have a question. Is the homeowners association required specifically outside of the notification for this Board of Adjustment case to notify the homeowners when a lot such as this is going to be developed? Because I would think the homeowners association was aware of the de facto use of that property, especially since they didn't mark it off as no trespassing or mark it off as like future development, like when people are planning to build in the future. Does anyone know about that?
I'll give you my thoughts on that. The homeowners association allowed this easement back in 0405. So quite some time ago. I would assume that under their covenants, they either had to have a vote of everybody or just in general have the power to grant easements over their common open space. If they don't have that power, then these people would definitely have a lawsuit or something like that based on that. But I'm assuming they do have that power. As a real estate attorney looking at this, I could totally see, there's all that common open space, and I could see somebody totally not paying attention to the fact that there's an area that wasn't. But in my title work, I should have gotten an easement that shows there's an easement to this little piece of property. More than likely, I may not have even mentioned that to a client, except for maybe the ones the three that are right there. We heard from two of the neighbors that are this property's kind of behind. To anybody else, there's sometimes easements and stuff, and it's really not affecting a lot of the people. It's not on the open space, but it does have the perception of being on the open space, but that's probably buyer beware on that, if I just look at the legal aspect of it. I don't know if that helps.
Were they, also required to like mark it off or, note it?
Not any more than you would be required to fence your yard if you didn't want to. You don't have to put a fence up. You don't have to do anything. And that would be on Mr. Etheridge if he wanted to keep people off of it. You could let anybody walk on your property anytime you want, I think, as far as just legally.
You're right.
It's definitely
a
tough deal with these neighbors that kind of, they knew they had common open space behind them, but most of us never look at I do just because that's what I do, but as far as the people that buy houses, almost never are looking at their plat to see where their yard is versus their neighbor's yard. And so they're just assuming, well, what's fenced here, that's what I'm buying. You aren't even thinking about anything else. It's this vacant land behind you. There's a little sidewalk. Well, that sidewalk is just on the open space. Just past it, it's private property. So it's kind of a crap deal, to be honest with you.
Yeah. Thank you for answering that for me.
Yeah, I don't know if that gets you anywhere, but that's those are my thoughts from the basis of what a real estate attorney would see looking at it. Any other thoughts about this from anyone?
Another thought, I guess, too, again,
Sure.
As Mr. Jackson often is prone to point out, the case before us is the adjustment of, the variance.
Yeah.
About which we haven't spoken much on that as far as the ingress, egress, along.
Yeah,
that without any other further access. So, that, I just want to remind that that's what we're actually going to be voting on.
The general rule is you can't have a lot without any access. This one does not, or without road frontage. This one doesn't have it. You can solve that if you have an easement and you have a variance, is my understanding on that. It's an
Mr. Chairman?
lot. Yes, ma'am.
I have a question for, I guess, Josh. When was this lot created? And what plat was it created with?
Let's see. Let me get.
I'm showing 1998, Mary, at least the plat I'm looking at. You probably don't remember it. but I see you were related to it vaguely back at that time in your career. But that's just the plat beside it.
Yeah, and so did that plat create the lot? That's my question.
I would say no, it didn't. It was left out of the plat. It was just, it's not part of it at all, but by all the platting that was done around the lot, it left us with what we have.
So is that a lot? That's my question.
It is not a lot. It is not, it's a parcel of land, but it is not a properly subdivided lot that's properly platted.
So is it eligible for a permit? That's my question. Irregardless of whether it has road frontage.
Right, Mr. Chairman, y'all are right on point. The applicant, if this body approves this variance, the next step would be for the applicant to file a final plan that would be recorded that memorialized this lot.
And would that have to go before LUCB and council, or is that something that's done internally since it's a one lot?
With plan developments, final plans do not need to go to the Land Use Control Board unless such a condition is provided in the plat, in the outline plan.
Okay.
So you're saying that this lot can just be created by a final plat, and that fits under the conditions and so forth that go with this plat, the number of lots and the outline plan and so on.
Correct.
That's what you're
Yes,
saying,
ma'am.
right?
Yes.
Okay.
Yes.
So this is Portia Skerlock one more time. So basically, since he was the owner of the land, he was aware that he didn't have any access. Since he's just been holding out.
Yeah, he definitely knew he didn't have access, and as of at least 2004, sounds like someone else did most of the development work, even though he was the owner, and they didn't realize this wasn't ever included, and so that's why he got the easement back then, so he could develop it at some point, but just hasn't done so for 15 years.
If you don't mind, I'm just going to make one more point
do.
on this. The thing that I struggle with on this variance from section 3.3.1b to allow a lot without road frontage. To me, it almost sounds like we're creating this lot with our vote. But that's not true, is it, Mr. Whitehead?
No, y'all don't have that ability. So it's, I guess at this point, since it's not yet a lot, a more apt description would be a future. We should have had the future word before that description.
Mr. Chairman, John Jackson.
Yes, sir.
Ms. Baker, you know what? I'm with you though on this, and technically speaking, I'm sure Mr. Whitehead, you're right. We're not creating a lot, but we paving the way for it, because without this vote, it could never become a lot. Is that correct, sir?
It could become a lot, but an unbuildable lot. So a useless lot, perhaps.
Okay. Thank you.
Any other questions or comments? Hearing none, I assume y'all are ready to vote. Mr. Whitehead, would you give us a roll call vote?
Mr. Malazri.
Yes.
Ms. Doss. I know Ms. Doss, she told me she had to leave at 5:30, but maybe she meant 5:13. Ms. Skerlock.
No.
No. Mr. Jackson.
No.
Mr. Claybrook.
Yes.
Ms. Baker,
No.
Mr. Let's see, Vice Chair Savage.
No, I find that the standards of the UDC are not being, of 9.22.6 are not being met, with unduly detrimental to the properties in the vicinity.
And one last chance, Ms. Doss? Okay, and Mr. Chairman?
No.
Okay, we have 2 ayes, 5 nays.
All right, the motion fails. Thank you all for coming down today. Mr. Whitehead, will you call our final case?
I will, and Mr. Chairman, if I want to point something out, Mr. Secretary has to be at the law school at 6 o'clock. So if we have a lengthy discussion and the board feels need to have more information and hold the case for 30 days, that certainly is a possibility. Item number 14 is docket BOA 20102, located at 7 Vance. The applicant is Front Street of Go, LLC, represented by David Lewis. The use district is the South Main SM district, and the request variance from item 722E2A to allow additional dwelling units within an apartment building.
Okay, so I guess then what I would do is ask the representative for the applicant, there's significant opposition. Would they be willing to go ahead and would they want to hold to kind of work out some stuff, to go over site plans with opposition, or are they wanting to hear the case today?
Mr. Lewis?
I will keep my comments brief, as this board has already seen this project in essence in July. So I can give a quick update, and then if the opposition takes their 10 minutes, they can have their 10 minutes, and I'm hoping that we can get through this today.
Okay. Why don't we do this then? I'm going to go ahead and swear you in.
Yeah.
So give your name and address for the record.
David Lewis, 1519 Union Avenue, Memphis, Tennessee 38104.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Given that we did hear this case recently, if you could give us an update on what has changed, what your plans are, then we can move to the opposition.
Thank you. And so in July, we received approval of a variance on density for up to 210 residential units on the site. The application before you is a request for some additional units up to 229. Essentially, the variance that we're asking for is that only, the 229 versus 210. And the purpose of the additional units was simply as we configured the site and got further into design, also learning more about the construction costs and trying to get the project to pencil out, it made sense for us to add some additional units. So at the end of the day, it may be 225, 226, but we've asked for up to 229. So some of the design and some of the aspects of the existing building have changed slightly, and I think we'll hear more about that. But essentially what we're asking for this board to review is the density question of going from 210 to 229. And I'll yield.
If I remember correctly, we had more than, what was our parking ratio before, and what would it be now?
The parking ratio was about 1.2 before, and it's still one per bedroom now. So we're fully parked for the residents.
Okay. All right. Very good. And so you're going to yield your time. You've got about 8 minutes left on that. So you get a total of 10 minutes for rebuttal if we want to go ahead and move, and so we can move to the opposition.
Please.
And Mr. Chairman, the opposition has organized themselves, and we're going to go in the following order. Ms. Fulkerson is first up to bat.
All right, Ms. Fulkerson, could you give your name and address for the record?
Yes, this is Holly Jansen Fulkerson. I'm at 2282 Madison Avenue.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, go ahead.
Great. On behalf of Memphis Heritage, I am voicing our opposition to the proposed development at the Nylon Net building. To be clear, we are not opposed to the density that the additional units will provide, and we are not opposed to the demolition of the 1970s section of the building. The part of this new plan that we are very much opposed to is the demolition of the original 1904-1907 portion of the building. Since 1987, this building has been listed on the National Register of Historic Places as a contributing structure in the South Bluffs Warehouse District. It is known for its arched, full-length window bays along its ground floor facade and its iconic tall masonry smokestack. It is a major part of the character of downtown, and it is visible from our skyline. The level of craftsmanship used to construct this and other historic buildings is impossible to duplicate in modern construction. This building provides a sense of connection for our city's residents and visitors alike. It is a tangible link to our past and contributes to the authentic sense of place that is unique to Memphis. In short, the Nylon Net building is irreplaceable. We understand the challenges involved in preserving historic buildings, but we can't help but wonder, has every avenue for historic preservation been considered? Why not involve an architect experienced in historic preservation in determining the feasibility of adaptive reuse? Have historic tax credits and other incentives been explored to help finance an adaptive reuse project? Why not construct a new building on vacant land instead of tearing down a historic building? What was the cost per unit when the plan was to save a considerable part of the building, and what is it now? How much profit stands to be made in either case? The UDC allows for the board to set conditions when granting a variance, including conditions necessary to preserve the character of the area and to protect property in the near vicinity. We urge the board to help preserve the character of this important part of downtown, and if the board recommends approval, we request that they place a condition that the building will not be demolished. Thank you very much for your time.
All right, thank you, Ms. Fulkerson. Are there any questions for Ms. Fulkerson? Hearing none. Mr. Whitehead, who do we have next?
Joey Hagan.
All right, Mr. Hagan, are you with us?
I am indeed.
Okay, will you give your name and address for the record for me?
Yeah, Joseph Hagan. I live at 211 Buena Vista Place, Memphis, Tennessee, 38112.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do indeed.
All right, go ahead, sir.
Well, first of all, I wanted to thank the Carlyles for making such substantial investments in our downtown. One bill is certainly a game changer. It's changing our skyline and certainly changing the face of our whole urban environment. So I want to thank them for that. I've lived in Memphis a long time and worked downtown most of that, so I've witnessed the miraculous resurgence of downtown, as have most of you. So I think we can all appreciate that. I realize that the variance here before you is for the additional units and the additional density, but I would like to make a case for preserving the historic portion of the building. I am an architect, and I've worked in preservation and adaptive reuse in Memphis since 1984. I started out a long, long time ago at Tony Bologna's office, and the South Main and South Bluff warehouse districts have countless examples of successful reuse of warehouses being converted into residential uses. One of the ones that we did, the one that led the way a long, long time ago for Henry Turley, was, of course, Paperworks that everybody's familiar with. That was followed by 415 South Main, 417 South Main, 378-84 South Main, the old Cricket Ranch. That was a fun one. All of these were warehouses converted successfully to residential use. Another project that my firm, I started my own firm a while back, worked on was the renovation of the old Piggly Wiggly warehouse right there on Front Street. Density was, in fact, an issue with that. We were able to add 2 additional floors to the top of the building. And again, all of these projects met the National Park Service's programmatic requirements for the renovation of historic buildings and subsequently applied for and received historic tax credits. So lastly, I just hope we can all take a look, a more critical look at the benefits and options of preserving the historic portion of the project. The old garage, the 1970s portion, we're not too terribly concerned about. But take a more critical look at following the Park Service guidelines and allowing the historic building to be reused with little density added to it. This is such a iconic piece of our downtown riverfront that I hope we can find a way to save it. That being said, I will relinquish the remaining of my time to the other folks. Thank you.
Thank you, Mr. Hagan. Are there any questions for Mr. Hagan at this time? Hearing none. Mr. Whitehead, who are we talking to next?
Ms. Ann Edgar.
Ms. Edgar, are you with us?
Hi, I'm here.
All right, if you'll give your name and address for the record, please.
Yes, it's Ann Edgar at 295 Hawthorne.
Okay, and do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, go ahead. Now, we have 4 minutes and 48 seconds right now.
All right, I'll be very, very quick. I just want to say, as a normal Memphian who loves downtown, that I don't know why we wouldn't do everything to preserve this building. It seems irreplaceable to me. And I believe that the design appears, as we've seen it in the renderings, it appears to be respectful of this original historic building, but it's not. And it takes so much away that I really think that the developer could just as well be leveling the building. So there's nothing more to say. It's just that I urge you to reject the variance.
Okay, well, that was
and I also would just like to speak to the historic character of the building, and that's what I'm arguing should be preserved. It's not about density.
Gotcha. Okay, very good. Are there any questions for Ms. Edgar? Hearing none. Mr. Whitehead, who's next?
Ms. Dana Gabriel.
Okay, Ms. Gabriel, are you with us?
Hello, and thank you for your time. As the former owner of this building prior to DRAPAC. Oh, yes. Sorry. Yeah. I heard the remaining time and tried to be fast. Dana Gabriel, 99 South.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, go ahead.
Very good. As the former owner of this building prior to DRAPAC, I'm very excited for long overdue development on this site and remediation of blight. I also applaud the applicant, like Joey, for their commitment to downtown, but I must strongly oppose this request unless there's a condition preventing the demolition of the historic structure. I personally put a lot of time and energy into helping preserve it in my brief time owning it. And so I'm familiar with it, but approximately 50% of the footprint of the site, as you know, the south side is newer construction from the 1970s, and there's no opposition to demolishing that at all. I will help. There's also no opposition to the new construction on that portion of the site with any density whatsoever. There's no opposition. You can also build, actually, you can add additional floors on top of the existing historic 1904 to 1907 portion of the building. So, and there's no opposition to new construction on top of that as well. In fact, there's a prior rendering at some point that showed that. But I believe the precedent for this construction is the Arrive Hotel, the brewery, Spaghetti Warehouse reuse, Chisca, Central Station, Lincoln America Tower, Crosstown, Universal Life. These incredible projects have proven what's possible, and they've set the bar on what we should be doing downtown. They also contribute to each other to create the character of an entire area. So it's detrimental if a major contributor to all of that fabric is lost. Adaptive reuse will certainly have its own challenges, and this building has indeed seen better days. But as Holly said, sole new construction will not be able to replicate the character of the original structure. So the application also cites structural, long periods of vacancy, neglect, and age of structure as factors in this request. But nearly every project I just mentioned above has the same factors, and these are now the iconic projects that receive the most accolades in Memphis. So it's also very rare for a building to be so far gone structurally to necessitate demolition rather than repair. So I don't see anything in the application that justifies demolition. So while the nylon net, like I said, has sat empty for way too long and we all want to see progress, we just want to make sure that we get it right. Thank you for your time.
All right, thank you, Ms. Gabriel. Are there any questions for Ms. Gabriel? All right, Mr. Whitehead, who's up?
We have two more. First, Bob Craddock, and then after him, John Morris.
Okay, Mr. Craddock,
Yes.
could you give your
Bob
name and
Craddock.
address for the record, please?
Sure. I'm Bob Craddock. I live at 303 Wagner.
Okay, do you swear to tell the truth, the whole truth, and nothing but the true stuff you got?
Yes.
Okay, go ahead,
I
sir.
live, as you can tell from the address, I live right in the middle between the Carlisle's current construction project and the proposed construction projects. I strongly support what the Carlisles are doing. They've done a beautiful job with their building so far at One Bill. I'm not here at all to object to the project. What I am here for is to ask the board to impose conditions on the construction process. We have learned through the construction of three of the number one Bill project what a horrendous impact has had on the residences on Wagner. Basically three attributes. One is the traffic. There are many times when the street is, if not completely blocked, certainly partially blocked. The construction workers, which run into, I'm guessing, the hundreds, use the street as a parking lot, even though this is a no parking zone. And their vendors totally disregard all laws concerning parking and trash. We have major. So all I'm asking is, as a resident here who's invested quite a bit in this neighborhood, is a condition of this permit to impose restrictions on traffic, construction traffic, keeping in mind we're going to have a major demolition process on the traffic, dealing with the demolition and the construction and the massive number of construction workers coming into the neighborhood.
Okay, all right, well, we've hit our time limit. Are there any questions for Mr. Craddock? Hearing none. Thank you for joining us today. We're going to move back to the applicant at this point, where you have, I think I had 10 minutes left. If you need that to respond, I'd urge you to respond first of why we can't save the question is, why can't we save the historic structure? I imagine that you would not be okay with us adding that condition, or we wouldn't be here still talking. So if you could help us out with that, Mr. Lewis.
Right. Yes. So in the July application, we included preservation of the facade up to the existing first floor. And subsequent to that, we've had two structural engineers, and just to point out, we did engage two different architects to look at the project, one from a new construction angle and one from a adaptive reuse, who's probably the preeminent local architect to do such a thing on a scale like this. We went down the path of the Park Service with the State Historic Preservation Office. The building in particular has challenges with the fenestration. The window sizes above the first floor are not great. Some of the projects that have been mentioned on this call, Paperworks in particular, and Tennessee Brewery, you look at those buildings before, just tons of glass, lots of windows, great opportunities for natural light. You look at 7 Vance above the first floor, very small windows spaced widely apart. The building itself is 180 feet wide, not really great for, again, natural light, the kind of typical sizes that people want for apartment homes. So going back to the design process, 2 different structural engineers reviewed the building with us. Inside the building, there's asbestos, lead, mold, and guano that has to be taken care of if it's a renovation project. There are large areas of structural failure there are large areas of water damage that goes from the roof down to the basement, and there are structures in the basement holding up the building structures that we don't know the vintage of those, the shoring, and it's quite a dangerous building to just go and walk around in. There's soft spots everywhere and a lot of damage. So with that in mind, and with the differential settlement cracks, the brick is in decent condition, but the building has to be upgraded to current seismic standards no matter what you do with it. And that's a huge process with a lot of unknowns. And you know, a lot of the projects that are mentioned in other cities, they don't have, you know, the seismic conditions we have, the soil conditions we have downtown. We're Class D soils, we're seismic zone, you know, 3.5, 4, basically the same as the West Coast. So anything you were going to try to do with this building would result in an immense amount of structural cost. And at the end of the day, you don't get the parking, because of the column spacing. It's a warehouse building, so the column spacing isn't really great for parking. It's probably fine for dividing up into apartment homes, but you don't have, you know, the value of this property is the river and the access to the future Vance Park and redevelopment of Tomley Park. And if you take a 180-foot wide building, there's really not a great way to cut it up and give people the access to the river. So I want to skip to Mr. Craddock, and I know we didn't get to Mr. Morris, but I've spoken to Mr. Morris. We'll submit, of course, a traffic control plan to city engineering, and I've already spoken with Mr. Morris about perhaps guiding the construction traffic Talbot, Vance, and out, not north on Wagner. So hopefully, Mr. Craddock, you know, we're bound on the west side by Tennessee Street and the railroad tracks, which again is another reason HUD was not interested in financing this project, and because of the proximity to the railroad tracks, another challenge in building. So we will put in the traffic control plan that construction traffic should enter or exit Talbot, enter or exit Vance, and not continue north on Wagner, and we can use signage to keep construction traffic from going that way. There were a lot of points made that I want to kind of run back through. You know, we used two different HUD consultants, acoustical consultants, to talk about perhaps doing the full Park Service adaptive reuse, and that was pretty much a dead end because of the railroad. We've got a 90 to 115 decibel noise levels 2 to 5 times a day, and HUD in their environmental review will not approve a project with those kind of noise levels. So the project was evaluated as adaptive reuse and evaluated as a new construction. The adaptive reuse, unfortunately, did not pencil out. It's not in a local landmarks district, so I'm not sure if you're trying to tell me I'm out of time, but
oh no.
Okay, but we also understand that with the other developments on the One Beale site, that you know, construction in an urban area can be very disruptive. So what I've committed to with Mr. Morris, and I'd be happy to talk to Mr. Craddock, is that we would set up an email list, or if all the neighbors are on Nextdoor, we can try to keep the neighbors a little better informed about when we're going to be doing early mornings or late nights, have a better avenue for folks to let us know if workers are not parking where they're supposed to, or that they're not being respectful of the streetscape there. But ultimately, when this project gets going, Wagner will be open to the north, to MLK, so that the neighbors of this area can travel north to MLK to front. They've got a light to safely get onto Front Street and get out to the rest of the city. So the entrances to the future parking deck in this project would be on Talbot and Wagner. Again, staying off of Vance so that the city has a really nice approach to the new entrance to Tomley Park and Vance Park. So the I think if there were other questions that I didn't answer. The increased density we feel is just well supported by the location. There's direct access to the trolley when it comes back online, probably about the same time this project comes online. And with the entrance to the deck being Talbot and kind of this on the east side of the building on Wagner, we feel like we're not competing too much with the folks in the co-op to the west. And we had some good conversations with them on the last go around here. So, and our traffic, our streetscape plans will be a huge benefit to the area. Right now on the south side, Talbot, it's just kind of dumpsters and drainage, and we're planning a public component on the south side of the building, perhaps a dog park or just another pocket park on the south side of the building, dress up the streetscape on the north. The smokestack, unfortunately, again, for the current seismic codes, and we're probably going to end up with the latest codes, bracing the smokestack. The brick exterior is in relatively good condition, as Ms. Gabrian noted, but the structure is unknown. It's connected to the building that is not up to seismic code, and so what you see in the renderings is a recreation of that. We're planning on reclaiming about 60 to 70,000 brick from the existing building and recreating that facade in the style of the existing building. Because really, when you look at 7 Vance now, the architectural detail is all in the first 20 feet or so of the building up to the first floor. So that kind of patterning of the openings, the arch openings, we carry that up on the corners. We carry it up in different parts of the building, and using that reclaimed brick, but with modern techniques and up to modern contemporary codes. So I feel like this development team did the due diligence on adaptive reuse. In fact, I spoke to Mr. Hagan during the process when we thought we might be able to go the route of HUD and the historic preservation through the Park Service, and ultimately that wasn't feasible due to the environmental review. And so, in order to make this project work, and a lot of developers have taken a look at this and come to the same conclusion that the site is best if it's cleared.
Okay.
So if
All right,
there are any other questions, I'm happy to answer.
Are there any questions for Mr. Lewis?
This is Vice Chair. I have a quick question on the additional 19 units. Are those is that going to be another floor from the original renderings, or is there another whole design from the first renderings we saw?
It's relatively same design. In fact, we have a little updated design into Downtown Memphis Commission now, but it's really just a reconfiguration of the units, adding a few units along Vance. So 2 floors of units along Vance. That's really where we got most of the units, and then kind of extending a middle E, if you will, towards that courtyard to the west. So there's still a really generous kind of courtyard on the podium, but added a couple stacks of units there. So same building footprint generally, a little bit of an overhang on the south side that we're talking to the city about, but same overall design aesthetic. In fact, not a whole lot changed between saving the existing facade and recreating the facade with the reclaimed brick. It's just the condition that the brick is in, based on letters that we have from the engineer and architect. They're just really concerned about being able to make that work with with the new construction behind it. And by the time you repoint and support everything that's there, we feel like it's safer for the demolition team and for the construction team to take it down, reclaim the brick, rebuild it properly.
Okay.
Thank
Other
you.
questions of Mr. Lewis? All right, hearing none, are there any other questions before we move to discussion? All right, then if someone could give us a motion to approve BOA 20-102 as conditioned by staff?
John Jackson, so move.
Is there a second?
Vice Chair, second.
Okay, is there any discussion?
Mr. Chairman,
Yes, ma'am.
Mary, you know, this is just a huge decision, is what it seems like to me. And, so I feel rushed. And so, if, you know, if we have to vote on this today, I would just have to vote no, because I don't still think I know enough about it, you know, to make the decision that the bill be demolished. And I deserve more discussion and more information and more people at it and report it. So that's just my
Could you list some, like, would you like to see the fully done site plan? Is that kind of what you're looking for?
Well, I think more that the thing that troubles to me is that there are just so many people looking at this building and they understand that it can be preserved and modern parts can be added. I've heard all the presentation now, you know, about what the various limitations to doing that. You know, I'm listening to I respect with the knowledge they have and so forth, and quick decision. I just don't feel comfortable. I'm just
Okay. Okay.
It's decision, and then
So I'm getting some feedback with your talking about. So just to restate, you would vote in favor of a hold, or you'd probably vote no, is what you're saying.
that is exactly what I'm saying. Yes,
Okay.
I would certainly hold to allow more.
Gotcha. So are there others on the board that feel similar to Mary, so we kind of know what direction we need to go, or do we need to pursue this?
Chairman. This is Carson. John Jackson. I prefer a hold as well.
Okay, so that's another hold. Mr. Jackson?
Jackson.
So, all right, so that's 3 in favor of the hold. Do we have anybody else?
I would say yes, just for a better rendering of the you know, footprint.
Okay, then, Mr. Whitehead, do we need to get a new? It sounds like with 4 people wanting a hold, rather than destroying this case right now, that's the direction we need to go. Procedurally, do we need to remove the old motion, or do we just vote on the hold because that makes more sense?
A hold is a procedural vote, so it would supersede the earlier motion. So we just need a motion and a second.
Right. Mary, would you like to make a motion for us to hold this case for 30 days?
Yes, I move that we vote to hold for 30 days.
Okay, is there a second?
Second.
All right, being moved and
Second.
seconded. Is there any further discussion on the hold? Hearing none, we'll do that by voice vote. All those in favor of hold, do so by saying aye.
Aye. Aye.
Any opposed? Hearing no opposition, the motion to hold carries. So we'll rehear this in 30 days, or at the next case, or at our next meeting rather. Mr. Whitehead, are there any further announcements?
I do not believe so, Mr. Chairman.
Okay, with that, this meeting is adjourned for the day. We'll see some of y'all next month.
Thank you.
Thank you all.
Yay.
Thank you.